Hello, my friends. Thank you so much for coming. Okay, we're going to try this again. Hello, my friends. Thank you so much for coming to spend part of your Tuesday with me. Today is, that's what I was trying to do, is get up to the corner of my screen and figure out what the date is so we can have that for posterity in the stream. Today's Tuesday, November 28th. And it is 4:30 p.m. here in New York. And, some days there's not a lot to report on, and some days there's a ton of stuff to report on. I see that Paul Clink was in the chat giving out some virtual snacks, which I thought was very nice. And welcome. If you've never been here before, I think you're going to like it here. We have a really cool chat and very friendly people. So if you'd like to introduce yourself in the chat, and everyone will make you feel at home. Scott, I hope you liked your pizza and you ate all the crust. Let's see. So some days there is nothing to talk about. Some days there is a ton of stuff to talk about. Did anybody watch the Alec Murdaugh sentencing today? Because that was fire. I was listening to it in the car while I was driving. And wow, what a speech Alec Murdaugh made all about himself. He spoke for almost an hour during the sentencing, and it was crazy. Just when you think you've seen it all. Thought we were going to be done with Alec Murdaugh, but I don't think we are. I think he's going to wind up getting a new trial, but that's just me. Oh, hello, Mick Ramblon. That's awesome. I'm so glad, Sarah, that you're able to join us live. It is so much more fun to be live, isn't it? Because we really get to interact. LB says he's got some nerve. Yeah, we're back on Murdaugh. Mick Ramblon, is that a Grateful Dead reference? Because you may notice wait, you can't really see it because it's kind of behind me, but there's some dancing bears up there, and that's like one of my special emojis or some dancing bears. So if it is like a Ramble on Rose reference, that's pretty awesome. We have a couple of deadheads in the chat here on the regular. Hey, Sarah, I heard Eric Bland tearing him a new one. Yeah. Scott's putting $50 on a new trial. I'd go higher than that. I think I'd go higher than that. I can't wait for that hearing about Miss Becky and all of that other stuff that they're going to have the hearing about. But that is crazy. So I went back and I was watching last night's stream again, and I realized that the little speech I gave at the beginning was referring to the motion that I'm going to talk about tonight. So I'm going to say this again. The motion that we did last night, the juror number 1 motion, that's some crazy stuff. That is not a motion that is common. It seems to be becoming more common, though, where they are attacking jurors personally. And it is interesting to note that when I went into the court file today, all of the personal information on juror number 1 has been redacted now. Isn't that nice? It was only up for what, 6 days, 9 days? It's out there. Everybody has it. Not only did they redact his name from the original motion, which was filed, I think, on, what do my notes say? Something like maybe the 22nd. Six days ago. It was filed 6 days ago. That's what I know. His information was out there for 6 days on the public court website. We've all seen it. Everyone's seen it. Everyone on YouTube who has covered it has seen it. It's been in the motion. Now they've redacted it, including the exhibits that we looked at yesterday, which included his juror number 1's Facebook posts. Remember how we looked at it last night and they did not redact his name, but they did redact the name of whoever he was speaking to in that post? Yep, including his home address, Cat Lady. You are correct. So I don't know whose decision it was to go back and redact that stuff. We know the defense firm has been watching YouTube. They're still watching YouTube. They're reading all the Reddit threads. That's where they're getting most of their information from, these anonymous sources that are sending them all kinds of things like pictures of Maya at Halloween, pictures of Maya at homecoming. So they have a lot of people on their side, and that's where they're getting their information, right, Scott? Hunter. That's where Hunter's getting all his information, and Shapiro, and they're getting all their information from the people on the internet. So what are we going to do? What we're going to do is we're going to read the motion. And what I'm going to tell you about this motion is that this is the motion that I was talking about last night when I had the preamble about this is a very common motion to make. Okay. Every time there's a jury verdict that is in excess of what the defendant wants to pay, or that is in excess of what the defendant had offered to pay to settle the case, you are going to see this motion. Basically, the motion says this. Well, this is a three-prong motion. They're asking for just about everything. Judge, we weren't liable. We weren't liable, Judge, and therefore you should just reverse the jury's decision and direct a decision in our favor. That's called a directed verdict. And just overturn what the jury did. And based on everything that we're going to tell you and all of the evidence that the jury heard during the trial, there is no way that this should have even gone to the jury. That's the first thing they're asking for, is a directed verdict on every single count that went to the jury. The second thing that they're asking for, and they're saying, okay, we're not liable. But if you think we're liable, there was some evidence that came in that we don't think should have been allowed in, and therefore you should let us have a new trial. That's the second part, motion for a new trial. The third part is, well, if you don't want to reverse the jury's verdict and you don't want to give us a new trial, the least you could possibly do is reduce the amount of the verdict, because the amount of the verdict, Judge, was totally excessive and it's against the weight of the evidence. And there are certain things that they didn't prove that they had to prove. And there's no way that a reasonable juror could come to this decision of awarding $261 million. Judge, it's just never been done before. So I looked it up. And there was a $1 billion verdict in Florida in August of 2021. That was a wrongful death case for a 19-year-old college student who was killed by a semi-tractor trailer in a car accident. And there was evidence that the tractor trailer driver was distracted by some text messaging. And so the jury verdict on the punitive damages was huge in that case. It was $1 billion. I think it was 900 million in punitives and 100 million in compensatory damages, pain and suffering, loss of income, pecuniary loss to the family. And he wasn't married. He didn't have children. So all the, everything went to his parents. I tried to find out where that case is on appeal, but I'm sure that it's going to be overturned, or perhaps it's settled. Sometimes that's what it takes to get the defendant to settle, is a huge verdict. And then they can settle within their policy limits. Maybe they didn't think that they were going to be held liable to the extent that the jury did, because I think the jury found them to be something like, I don't remember what the breakdown was on that. I'm thinking of another case. But in a case like a car accident, the jury can assign fault 75% defendant, 25% plaintiff, or if there's multiple cars, they can assign a percentage of fault to each defendant, in which case the verdict would be reduced with regard to the verdict would be reduced dependent on how much the plaintiff was found to be at fault. Follow me? Okay. So where we are right now is this was the motion that was filed on Friday, the day after Thanksgiving. The court was closed, and it did not come up into the court file until yesterday. And then when I was going to do it yesterday night, all of that other stuff all of a sudden dropped into the court file around 1 p.m. Eastern and then 4:30 p.m. Eastern. So we covered that stuff last night. That was the plaintiff's response to the defense motion to get rid of juror number 1, or to have him to get a new trial based on the misconduct or the alleged misconduct of juror number 1 and his wife and Jules, which made no sense to a reasonable person. And we looked at also their additional response, where they doxed juror number 1 again by putting out some information again about a DV proceeding that he may or may not have been involved in 2002. That has also been locked up in the court file under seal. You can't even get to that document anymore. It just was not redacted. It was locked up. So I find that interesting. All of a sudden, everything is redacted and everything's locked up. But here we are, and I'm here with you for it. So let's take it from the top, shall we? We're going to look at this motion, and I'm going to preface this again by telling you that this is done in every single case. A lot of people are freaking out about this. There's nothing unusual about it. No defendant wants to pay. No insurance company wants to pay. Insurance companies are not your friend. If you've ever had any kind of personal injury case, whether it be you were a plaintiff in a car accident, a medical malpractice case, a trip and fall, a dog bite, any kind of liability situation, a negligence case, it is like pulling teeth to try and get the insurance company to pay. And they'd rather pay their attorneys by the hour to fight it than just pay it. And that's just the way it is in every single case. I know we're all emotionally involved in this, but it's just the way it is. So here we go. This is Defendant Johns Hopkins, All Children's Hospital's renewed motion for a directed verdict, motion for a new trial, and motion for remittitur. Remittitur means reducing the verdict. Everyone make sure to hit the like button on your way in. As Miss Donna Marie is saying, Queen of the Mods, thank you. I do have the best mods on YouTube, and I'm not afraid to say it. They really are. So welcome, everyone, but be kind to each other. That's all. That's all we ask. Defendant, Johns Hopkins, All Children's Hospital. This is, by the way, 144 pages. A lot of it is very repetitive. So I'm going to just, we're going to go through it. I've highlighted it. I've read it. I've looked up some things. I've researched, did a lot of work on this. Paul says, what are these rumors I keep hearing about juror number 1 living with his wife? I know, that was last night. And the night before Thanksgiving, we talked about that, I think. Thank you, Stacy. Oh, thanks, Stacy. It's a good ring light. It's the key. The key is a good ring light, but thank you so much for your compliment. I appreciate you. All right. So again, here's what they want. Renewed motion for a directed verdict. And if those motions are denied, they want the motion for a new trial. And if those motions are denied, then they'll accept a motion for remittitur as to each of the 3 plaintiffs and as to each of the claims submitted to the jury on the verdict returned on Thursday, November 9th, 2023. Yeah, last night was hilarious. Everyone had a really good time in the chat last night, right? We were laughing. We talked about Seinfeld. We talked about Office Space. Oh my gosh, Janai, no, you are not late at all, honey. You are right on time. I just started on this first page. This is a 3-pronged motion by the defendant to get everything that they want and to give nothing to the plaintiff, basically. They would like the court to order a renewed motion for a directed verdict on every single count that went to the jury. And if the judge doesn't want to do that, then they say, well, then we should get a new trial. And if the judge doesn't want to do that, then they say, well, please reduce every single award that the jury awarded because we don't think there's any way in hell that they should have awarded that much money. The defendant also moves this court to grant the same motions concerning each of the claims for punitive damages for the 3 subclaims for false imprisonment and the 1 subclaim of battery, for which the jury returned the bifurcated verdict later in the day on November 9th of 2023, awarding a total of $50 million to Maya Kowalski as punitive damages. This motion is unavoidably lengthy, but in the end, this court has little choice but to direct a verdict on all claims for which the defendant should have received that relief earlier and to grant a new trial on both liability and damages for any remaining claims. Right, Janelle? Because they were just 6 people at a bus stop. That's right. They were just 6 people at a bus stop who do not know nothing about nothing, right? The jury voted yes on every possible method to award compensatory or punitive damages against Johns Hopkins, All Children's Hospital. Under the leadership of juror number 1, the jury voted yes, despite the fact that under the law instructed by the court and the evidence presented during the trial, many of the claims were not proven, or at a minimum, the manifest weight of the evidence was contrary to a yes vote on that claim. stop for 1 second just to point out to you that they are going to mention juror number 1 a lot in this motion because they think that juror number 1 was in charge. And obviously he and his wife conspired to get everyone on the jury to rule in the hospital's favor because he was biased. That's what they think. It couldn't be possible that they just voted yes on every claim because that's what they really felt. But I digress. This court allowed plaintiff's counsel to use an improper method of closing argument that was intentionally designed to mislead the jury about both the method to decide damages and the reasonable range in which the jury was free to operate. In the improper closing argument, plaintiff's counsel requested aggregate damages of $201,573,728. The jury awarded $211,451,174. I can't remember who was doing the math with me that night. I thought our math was right. Approximately 105% of that request. Both the awards for the personal injury claims of Maya Kowalski and for the wrongful death of Beata Kowalski are many times higher than the range currently awarded by other juries and recognized in case law for such awards. And now look, that is a valid argument as much as we don't want to like it. There are such things as sustainable verdicts in every jurisdiction. And that will always factor into a defendant or a plaintiff's appeal, whether they appeal or not. Is this verdict sustainable? Now, they are required to pay interest on this verdict. I've heard a lot of misinformation out there on the interwebs, so I'm going to explain to you how the interest works. First, they have to enter a judgment. Once the judgment is entered, once the verdict is entered in the form of a judgment, the Florida statutory interest rate, and it changes every quarter apparently, is 7.69% per year. So if they do appeal the amount of the verdict, and the verdict is upheld in the amount of $261 million, that's a big chunk of change at 7.69% per year. But that's only if the number is upheld. Okay, and that's after the judgment is entered, after the verdict. Everybody get that? All right. Where did we leave off? Under the leadership of juror number 1, the jury's verdict was obviously tainted by the improper closing argument of plaintiff's counsel, but it sometimes awarded amounts even higher than plaintiff's counsel requested. It is patent that the jury did not award non-economic damages as if these claims had been tried separately. And the same is true for economic damages, for which duplication of award is rampant in the verdict. This court, before that closing argument, committed to following the law after the return of the verdict if plaintiff's argument resulted in such a massively tainted verdict. The awards are so arbitrary that they cannot even be used as a reliable measure for remittitor. A remittitor in this case would simply require the court to serve as a fact-finding jury of 1. This court must grant new trial as to liability and damages on any claim for which a directed verdict is not granted. After the jury returned its verdict determining liability, compensatory damages, and making findings on the substantive issues allowing for an award of punitive damages under Section 768.72 of the Florida statutes, this court proceeded immediately with an abbreviated trial on the amount of punitive damages, in part because the case needed to be completed on November 9th for the reasons asserted by the court. I knew that this was going to be a problem, and I didn't understand why they had such a hard stop on this. In my opinion, and my opinion only, that can be construed that the jury has to be done and they have to come to a decision on November 9th. I know that he said he had another trial scheduled, but that trial could have been put over, in my opinion, until this verdict was rendered. I don't think they should have put a hard stop on it. Just my opinion. The plaintiff proposed a verdict form for the first time that included a claim under section 768.731C that the punitive damages should be unlimited because the defendant had a specific intent, in quotes, to harm Maya Kowalski. Not only is there no evidence that would establish that claim, but that claim is very clearly a substantive claim involving the entitlement for damages in excess of those normally allowed under 768.72 Florida statutes. Okay, so Florida has a cap on their punitive damages. The cap on punitive damages in Florida is either $500,000 or 3 times compensatory damages, whichever is greater, unless you can show a specific intent to harm the plaintiff. Then you can, what they call, bust the cap and award whatever amount of punitive damages that you want. Make sense? Okay. They go on to say, as a matter of basic due process, this claim under section 768.73 of the Florida statutes needed to be pleaded in the 8th amended complaint by something more than a conclusory claim that the defendant had acted willfully, wantonly, or maliciously. The defendant needed to have the opportunity to present evidence on that claim prior to the initial verdict in this bifurcated trial, to move for a directed verdict on the claim at the close of the plaintiff's case, and to argue this matter in its main closing. Instead, this court placed this substantive issue affecting the cap on the punitive damages on the jury's verdict for the second phase of the bifurcated proceeding, where only the damage amount should have been tried. Moreover, this court declined to decide this question of law concerning the burden of proof for the specific intent finding. It thereby further emphasized this issue by presenting it twice to the jury under optional burdens of proof. The jury then returned a verdict, again voting yes on everything, under the leadership of course, guess who? Juror number 1. The jury awarded $50 million in punitive damages. It awarded $25 million for 2 false imprisonment claims for periods where 1, Maya Kowalski was treated in an intensive care unit, and 2, she was observed for 2 days in a rather ordinary hospital room. And the video recording in evidence shows no mistreatment warranting any punitive damages. The jury awarded another $25 million for a combined false imprisonment and battery, where she was placed on a bed either in her own hospital room or some other hospital room for a matter of minutes on January 6th of 2017, which is the day she went to the courthouse. This is the day her mother wrote her suicide note, unaware of this incident. Okay, so do you disagree so far? I'm going to go to the chat. Do you disagree so far with anything that you are hearing? And if so, why? Yes, an ordinary room with a hidden camera, says Daily Quick Bites. Yeah, you're going to see they're going to use a lot of gaslighting language in here. So don't freak out, everyone. Not just you, Daily Quick Bites, but yeah. The way they categorize everything and describe everything is going to seem like they're minimizing it, and that it's just not my style. Like I'm snarky in real life, and you know that. If you watch me all the time, you know I'm snarky. You come for the snark. But in legal pleadings, I don't think that I would start minimizing the plaintiff's experiences in a way that would use descriptive language that is, in my opinion, a little bit derogatory. That's just me. Oh, Maddie. Hey, Maddie. And he says, I disagree because she was dropped on the way to the PICU. Well, that's interesting because they don't even talk about that in this motion. And Scott, here's a warning for all of you. Please don't discuss the case. And if you do, you can't be married or live in the same residence as your significant other. Thank you. Sarah says I should turn myself in and live with an attorney. Okay, we'll keep this for later. So hang on to this thought, Daily Quick Bites. I'm going to even star this. Performing ops to try and catch the kid faking and disguising that as treatment is evidence of specific intent. Okay. Hang on to that thought. Okay. This is The jury awarded another $25 million for a combined false imprisonment and battery, where she was placed on a bed, either in her own hospital room or some other hospital room, for a matter of minutes. Again, a matter of minutes. On January 6, 2017, which is the day she went to the courthouse. This is the day her mother wrote her suicide note, unaware of this incident. That's going to come into play later when they're going to say that Beata didn't even know about this, so how can you award her damages for something that she didn't even know about? Maya Kowalski was held on a hospital bed to document the condition of her skin photographically prior to leaving the hospital. She had her shorts and bra on for these photographs, which were not shared or publicized at all by the defendant. Well, kudos. Kudos to you, hospital, for not publicizing them or sharing them on your website. I can't even. Like, what, really? It should be noted that the defendant maintained that she was actually photographed again on her return, but in light of Maya Kowalski's insistence that it occurred once, this verdict is only for a single event. Maya Kowalski saw both her uncle and her psychologist, Dr. Duncan, on that same day. She seemed essentially normal to her uncle on that day, and she made no complaints to Dr. Duncan. The jury determined this conduct was more than an intentional tort. It decided that it was, quote, intentional misconduct, end quote, under the definition in Section 768.72 Florida statutes, and awarded an amount of punitive damages that would be excessive, even in an Engel wrongful death case, where a plaintiff suffers for years with breathing disorders allegedly brought on by an addiction to cigarettes. That says an addition to cigarettes, doesn't it? Should say an addiction to cigarettes, caused by the fraudulent conduct of a large for-profit international corporation. The Engel cases in Florida, and they spelled it wrong. It's supposed to be an E at the end of that. I don't know who's not proofreading, but I'm a stickler for grammar and spelling. So the Engel cases are a class action group of cases against the tobacco companies. This was the tobacco litigation. And if it was determined that you were a member of the class, then you would not have to prove certain things at trial. Such things that, like, the tobacco companies knew that tobacco was addictive, that they promoted it as not being addictive, all kinds of things that were automatically assumed, and you only had to prove basically damages. So, that really doesn't have anything to do with this case, but it does come into play because a lot of those verdicts that were very, very big in those Engel cases were not sustained. This motion is filed within the mandatory 15-day window that is provided for all cases without regard to their complexity or trial length. Although a full transcript was requested shortly after the return of the verdicts, and some transcripts or portions of the trial are available now. The motion for this exceedingly complex and lengthy trial is not as comprehensive as it would be with a full transcript and with sufficient time to address a case that is easily 9 times more complex than the normal case in which such a motion is filed. And I have to agree with them there. This is an incredibly, incredibly complex case. And the trial transcripts after 9 weeks of testimony and court every single day are crazy long, tens of thousands of pages. So, they could have moved for an extension to try and get this filed, but instead they made the motion, which is probably the right thing to do. But again, I do agree that 15 days and, the fact that that day fell on the day before Thanksgiving or the day after Thanksgiving was unfortunate for everyone. Rule 1.53b specifically provides for an amendment to the motion to state new grounds. The defendant has sought to identify each ground for this motion, but it will seek to amend its motion for any additional ground and to provide greater factual information and legal argument as soon that is feasible. And somebody was working very, very diligently right through Thanksgiving to create this incredible table of contents. I mean, look at how much stuff is in here. It's 5 pages or more of just 6 pages of just table of contents. Let me look to the chat for a second if I can get out of this screen. What is going on here? All right. First, they're going to talk about the applicable standards for these motions. And they're going to say, and it's going to be the same pretty much for every claim, but this is the standard. This is the law. Because the plaintiff presented multiple claims and subclaims, this motion will provide the standards for the motions at the inception and refer to these standards in the motion directed to specific claims and subclaims. The several motions and standards are listed in the table of contents preceding this section. The defendant first seeks a directed verdict on most claims. Should the court deny a directed verdict as to any claim, the defendant alternatively seeks a new trial on those claims for which a directed verdict has been denied. If the court denies a directed verdict and a new trial on any claim, the defendant next seeks remittiture of the damages associated with those claims for which a directed verdict and new trial have been denied. The defendant is not waiving its right to appeal motions by raising alternative motions in the event that the earlier motions are denied. And if that doesn't make your head spin as a layperson, it makes my head spin as a lawyer. But it is very common to ask for alternative forms of relief, and you are allowed to do that. And it is efficient to put everything into one motion instead of having several different motions that the court has to catalog and respond to and decide on. All right, so they're first talking about the renewed motion for a directed verdict. A motion for a directed verdict should be granted only where no view of the evidence or inferences made therefrom could support a verdict for the non-moving party. In considering a motion for a directed verdict, the court must evaluate the testimony in the light most favorable to the non-moving party, and every reasonable inference deduced from the evidence must be indulged in favor of the non-moving party. If there are conflicts in the evidence or different reasonable inferences that may be drawn from the evidence, the issue is factual and should be submitted to the jury. A renewed motion or reserved motion is subject to the same standard. Sometimes, however, it is more apparent at the end of the case that an essential element of a claim was not supported by any relevant evidence, or that the evidence on the issue was not in actual dispute. With the initial motion, the trial court has the luxury of anticipating that the jury will likely vote in favor of the party moving for a directed verdict. Once the jury reaches a verdict influenced by prejudice, passion, or simple confusion, it is the duty of the court to make the objective decision based on the law and the actual evidence. What they are saying is true. Like we always discuss on this channel, the jury is the finder of fact in these cases. It's not the judge, it's the jury. They are the finders of fact. The judge would rather have the jury throw it out than throw it out himself. Just the way that it is. Judges do not like to be overturned on appeal. And so it is preferable to let the case go to the jury. But if the moving party, in this case, the defendant, can show that the judge should have decided as a matter of law that a particular cause of action should not have been allowed to go to the jury, it can be overturned. Oh, I'm sorry, Phoenix Rising. You didn't get your notification? What? This is a past stream? You know, I noticed that on somebody else's. I was watching somebody else today, and it said 18 hours ago they started, and they were still going, and I was like, what? That's really weird. I don't know. YouTube glitches are gonna be my demise. But we just gotta roll with it. Next, they're saying that they should get a new trial based on the manifest weight of the evidence. Motion for a new trial based on a verdict that's contrary to the manifest weight of the evidence may be granted even when a motion for directed verdict is unavailable. So if you don't want to give us a directed verdict, judge, according to the case law, you can give us a new trial. The trial judge should always grant a motion for a new trial when the jury has been deceived as to the force and credibility of the evidence or has been influenced by considerations outside the record. Citing a case from 1959. When considering a motion for a new trial based on the manifest weight of the evidence, the Florida Supreme Court held in Van v. Schmidt that A trial court is not required to defer to the jury's weighing of conflicting testimony in considering the motion. Rather, in making its decision, the trial court must necessarily consider the credibility of the witnesses along with the weight of all of the other evidence. The trial judge should only intervene when the manifest weight of the evidence dictates such action. In other words, it is the trial court's responsibility, not the district court's, to weigh the evidence, consider the credibility of the witnesses, and determine whether the jury has reached an unjust decision on the facts. So in Florida, the first remedy is to go back to the trial judge to ask him to overturn the verdict. You can't go right to the appellate court. That's why they are making this motion in front of Judge Carroll, and he would have to rule on it. And then whichever way he rules on it, you can bet that the losing party will appeal that, and that will go to the appellate court. There are aspects of this case, they say, that made it difficult for the jury to weigh the evidence or follow the law. The medical and scientific evidence was complex and overshadowed by the emotional impact of a good family devastated by a dependency proceeding that was beyond the defendant's control. Okay. It may have been beyond their control, but we've talked about this several times in this channel, and I have submitted to you that yes, perhaps that is true, but they did set the wheels in motion. They set the wheels in motion. But for them making that second call to DCF after the first call, the case was closed. That would be my argument there. They set the wheels in motion for this chain of events. We'll see if they make that in their response. Hello, Mr. Anderson. Here's a good argument for you. Moreover, the tort of intentional infliction of emotional distress, even without the additional unique factor of suicide in this case, is a difficult intentional tort for a jury to understand. In this case, the jury needed to sort out any actions of the defendant's employees that were more than negligence. And more than a mere traditional intentional tort. They needed to identify conduct that actually rose to the level of extreme and outrageous conduct committed with the intent to, or with reckless disregard of, the high probability of causing severe emotional distress. To perform that task when presented with an emotional case and with a family sitting for weeks at the trial table, and in a high-profile case presented to a national audience, would be nearly impossible for most juries, even with a different foreperson. Oh, are they backing off their claim that juror number 1 and his misconduct caused this terribly excessive verdict? I don't know. But we have to keep this in mind because this is intentional infliction of emotional distress. And they are right. That is what the standard is. They have to show intent. Intent to cause severe emotional distress. We'll get to that because they're going to go through each count or each cause of action and say what they think the evidence was. And then we're going to talk about what we think the evidence was. The court is given a higher gatekeeping function for this unusual tort, and that function continues through the decision to determine that a verdict was against the manifest weight of the evidence. Finally, this standard and the job of the trial court is even more important in this case, in which the theory is that the employees of the defendant committed conduct that was so extreme and outrageous that it was the legal cause of a person's suicide. A suicide that occurred not because those employees directly interfaced with Beata Kowalski after October 13th of 2016. Instead, a suicide that occurred because extreme and outrageous conduct of employees inside the hospital was either described to Beata Kowalski by her husband or were experienced by her through some remote form of communication. A suicide that purportedly is the legal responsibility of the defendant and not the intervening independent act of Beata Kowalski, because somehow the defendant's employees intended their actions to cause this extraordinary level of stress in a woman many miles away, a woman that some of the employees had never met. The gatekeeping job of evaluating the manifest weight of the evidence for this claim is exceptionally important in this case of first impression. Okay, So it has in Florida's history of negligence cases, it has never, ever been found that a defendant was liable for a suicide. I believe that's what they're saying here. I think that we can agree that we've seen other cases in other states, criminal cases, where people were cyberbullied and encouraged to commit suicide. But they're saying in Florida, this is a case of first impression. There has never been a case that has held that a person's independent act of unaliving themselves was a result of intentional infliction of emotional distress. I kind of find that hard to believe, but that's what they're saying. Sarah says, first time for everything. I'm going to check in with you guys and see how you're doing. Hi, Daily Quick Bites. It's reasonable to infer from the evidence presented that certain JHatch personnel held personal animus towards Beata and sought to do her harm. I'd say yes, yes. But the plaintiff has to show that Beata knew that. That Beata knew that this was happening, and that's what caused her. You see, there has to be a causal connection there. She has to have known about it, and it has to be shown that because she knew about it, that is what caused her to unalive herself. Going back to the lingo that we have to use on YouTube because the YouTube police are real. Janai, doesn't that contradict what he was witnessed yelling outside the courtroom, calling the family effing trash or whatever he was quoted saying by two different witnesses? Why is he so emotional? I think we are all emotional about this case. We all are. Hi, Peter. Hi, Peter. Nice to see you. Good evening. Mermard. I'm gonna say it's mermaid. Mermard. The family court listened to the hospital to make all its decisions. So even though they didn't bring that in, it's still reasonable to believe they had a role. I agree with you. They're gonna turn around and say it wasn't us. It was Sally Smith, and Sally Smith wasn't part of the hospital. That's what they're gonna say. So buckle up. How could she not know they cut her out? I don't know. Oh, how could she not know? Or you're saying how could she know? Lynette, if Jay Hatch's employees didn't do what they did, and if Beata never went there, she would still be alive today. I don't know. I don't know that. How can you prove that though? And I'm just playing devil's advocate here for a second. And we all felt the same way, that her maternal instinct is what drove her to take her own life in sacrifice for her daughter. That's what we were talking about here. But I think it's a leap to say that she never would have contemplated unaliving herself for some other reason in the future. I don't know that you can make that determination. How could she not know based on their quick bites? How could based on her actions that they held animus towards her? Yeah, I mean, I think it's obvious. But they're saying these specific acts. We're going to get into it more because they're going to say there are certain specific acts that she did not know about or could not have known about because she was not there when it happened. So let's get into the standard a little bit more, and then I think it'll become a little bit more clear what I'm trying to say. A motion for a new trial based on errors occurring during the trial. A motion for a new trial based on legal errors occurring during the trial is analyzed separately from a motion based on the manifest weight of the evidence. As explained in Harlan Bakeries, a trial court has broad discretion in deciding whether to override a jury verdict on the ground that it is contrary to the manifest weight of the evidence. However, the closer the issue comes to being purely legal in nature, the less discretion a trial court enjoys in ruling on a new motion. This is so because an error involving a purely legal question can be as accurately reviewed from an appellate record as from the trial judge's bench. That case explained that the then applicable legal standard the trial court must use in deciding a motion for a new trial based on errors at trial when an objection was overruled during the trial is whether the error is so pervasive or prejudicial that the injured party is denied the right to a fair trial. But the applicable prejudice analysis has changed since that case, Harlan Bakeries. A new trial is required where the judge becomes aware of a specific prejudicial legal error, or when he or she finds that the jury verdict is contrary to the manifest weight of the evidence. This means that when considering a motion for a new trial based on prejudicial error, the trial judge, who must decide whether to grant a new trial on the proffered ground that some reversible error of law occurred at some point during the trial, need only ask himself if there was error, and if so, whether the error was substantially prejudicial. In that instance, the judge is required to sit in essence as an appellate judge. If he concludes that reversible error has been committed, the judge is obliged to grant a new trial on the same basis that an appellate court would do so. So that's the same thing that we were talking about before, that the trial judge, juror number 1 is here. Hi, juror number 1. Juror number 1, I'm so sorry about what happened to you. I'm so sorry that you were dragged into the public record. Let me see where you are. I mean, if that's really you, I don't know. You could be Bus Benchers United. I mean, there could be a lot of people impersonating you now. I mean, like, you're a really big deal out there in the YouTube universe, apparently. So I don't know if it's really you. But if it is, look, I apologize on behalf of the defendant. I have nothing to do with the defendant. Listen, we were a pro-plaintiff channel all the way, and they didn't mention us in any of their motions. Thank you very much, because we're just not big enough, I guess. But I am very sorry for what happened to you. I think it was in very poor form. And I did notice that I went into the court file today, and all of your personal information is redacted, if that in any way makes up for them doxing you, which I'd be pretty mad about if I were you. But that's just me. Oh, yeah, you're in trouble again. I think it's a bot. Is it a bot? I don't know. If you are really juror number 1, I think it's terrible what happened. But I'm pretty sure that's a bot. Erica, I think J. Hatch contributed a great deal. They knew they were hurting her mentally and emotionally to the point of her predicted self-harm. I do think Beata does hold some responsibility for her actions. Here's the thing, Erica, and I agree with you, and I think a claim for negligent infliction of emotional distress would have 100% succeeded. But that claim was dismissed. So the only claim that went to the jury on this was intentional infliction of emotional distress, and that has to be proven by the weight of the evidence. And we're going to get to it, but 100%, do I think it was negligent infliction of emotional distress? Yes. Do I think that it was foreseeable that they knew that this could possibly happen? Well, yes, because Dr. Laura Vose, in her text messages to, I forget who, said, oh, I could have predicted this. Sorry, my predictions came true. This happened when I was a resident. We had another mother unalive herself. They knew it was foreseeable. And I think it was it Tepa Sanchez who testified that when she first met Beata said something to her like, oh, I just want to go to heaven. Sometimes I just want to end my life. Well, that goes to foreseeability too, doesn't it? So. Juror number 1 was an officer of the law, and he definitely followed the rules of the court. Anderson should have mentioned that in his motion. Yeah, and I also think, here's something else that I realized after we went through his entire response, Anderson's response. I don't think there was enough attention given to the fact of, like, how dare you ask for juror number 1 and his wife's electronics and social media history and Google searches. Like, how dare you? Like, I would have really had a lot more to say about that. I thought it was kind of glossed over, right? I mean, we did go through the entire response. I just didn't think that they hammered home on that. Like, what, are you kidding me? Like, if you grant them having to turn over their cell phones and their search history and their social media accounts and seize them, nobody is ever going to want to serve on a jury from here on out, ever. I think that was something that should have been hammered home a little bit more, but that's just me. Maybe they thought it was so ridiculous that they didn't have to address it. Hi, Cece. Some of this language is not case specific, right? Because they're talking about other cases. This is just a generalized overview. This is sort of like their introduction where they're telling the judge, here's what we think and here are the reasons why. And then we're going to get into the specific facts of the case. Yeah, TJ, I agree with you, TJ, man. Exactly. I don't want to be a juror if I'm going to be stalked by attorneys. No way. Or the general public or Reddit or chatters on YouTube, the nasty chatters that we saw in Law and Crime and Court TV. I mean, they were nasty. Yes. Shame on you, juror number 1, for living with your spouse and being married. And on we go. They cite some other cases, and then they say an appellate court will reverse a judgment or grant a new trial if a prejudicial error has resulted in a miscarriage of justice. This prejudicial analysis, also known as the harmless error analysis, is not limited to the result in a given case, but it necessarily concerns the process of arriving at that result. The Florida Supreme Court has announced the test for determining prejudicial error on appeal in a civil case as follows. Okay, so here's the test. We're going to see if this meets the test. To test for harmless error, the beneficiary of the error has the burden to prove that the error complained of did not contribute to the verdict. Alternatively stated, the beneficiary of the error must prove that there is no reasonable possibility that the error contributed to the verdict. Kind of like proving a negative. So he's saying that the plaintiff is going to have to come in and say, all these things that we're saying that the judge did wrong, now the burden shifts to you, plaintiff, to show none of these things that the judge did wrong could have possibly contributed to the verdict. Thus, as in State v. DiGiulio, the responsibility for proving harmless error remains with the beneficiary of the error, who must demonstrate that there is no reasonable possibility that the error contributed to the verdict. As the appellate court evaluates whether the beneficiary of the error has satisfied its burden, the court's obligation is to focus on the effect of the error on the trier of fact and avoid engaging in an analysis that looks only to the result in order to determine harmless error. Could the admission of evidence that should have been excluded have contributed to the verdict? Could the exclusion of evidence that should have been admitted have contributed to the verdict? Unless the beneficiary of the error proves that there is no reasonable possibility that the error contributed to the verdict, the error is harmful. Thus, the party moving for a new trial must show that there was error, and if so, then the burden shifts the non-moving party to show that the error did not contribute to the verdict. Next prong of this motion is that a new trial can be also based on an excessive award of damages. And they're saying that if the judge decides that remittiture or reduction of the verdict would not be possible, then you have to grant a new trial. This motion is based on errors during the trial affecting both liability and damages, and not merely the jury's own mistake in awarding an excess amount. These are often errors that cause the amount in the verdict to be so unreliable that the verdict cannot even be used by a judge to remit to a lesser amount that is legally appropriate without merely becoming a jury of one. A new trial may be ordered based on an excessive verdict when the record affirmatively shows the impropriety of the verdict, or there is an independent determination by the trial judge that the jury was influenced by considerations outside the record. Some cases still use an older test, holding that it can be granted when the verdict shocks the judicial conscience. Well, I mean, considering they already had $1 billion verdict in Florida, I don't think $250 million would shock the judicial conscience, do you? What say you, my friends? What say you? I don't think so. That $1 billion verdict in Florida was in Nassau County, Florida, and it was in August of 2021. So, I mean, if that verdict is out there, then, if it was $2 billion, maybe, but $250 million. I don't think there's an issue with that. Especially when it says here, the question is not what amount the court itself would award, and the judge does not sit as a proverbial seventh juror. The legal question is whether the verdict is so inordinately large as obviously to exceed the maximum limit of reasonable range within which the jury may properly operate. Especially when the verdict is deciding economic damages that require proof of a clear factual basis for the damages need to be reasonably supported by the evidence. It is incumbent upon a plaintiff in a trial court to present evidence to justify an award of economic damages in a definite amount. Damages are recoverable only to the extent that the evidence affords a sufficient basis for estimating an amount of money with reasonable certainty. And we saw that in the testimony of the economist. And those were the tangible damages. She had all the calculations for future lost income, future medical expenses. While remittiture can be an appropriate remedy for excessive damages, that remedy does not replace the remedy of a new trial. There are times when it is impossible for a judge to perform the act of reducing a verdict. If, in the opinion of the trial judge, it should be impossible for him to fix and determine a proper amount of remittiture, then he is directed to grant a new trial on the question of damages only. In this case, for many of the claims, the awards in the verdict are so... just lost my thought. Excessive, so beyond the proper range, due to the improper argument of plaintiff's counsel that this court allowed him to make at his own risk, that they really provide no benchmark from which this court can perform a reduction as a question of law. Moreover, as a result of additional errors, a new trial is warranted on all issues for all the claims in this case. Here's the standard for a motion for remittiture or reduction of compensatory awards of damages. The defendant in this motion will move for remittiture only as a last resort. The defendant does not actually believe that any of the monetary awards in this verdict are just sufficiently accurate and unaffected by passion and prejudice such that they could be used by this court to make a legal decision as compared to a factual decision to reduce the amount in the verdict to an appropriate amount. If the motions that precede a motion for remittiture are denied in an order resolving these post-trial motions, the defendant will appeal those rulings from the final judgment that is entered either with or before any order of remittiture. That order gives the other party the option to accept the remittiture and reduce the amounts in the final judgment or to request a new trial. They're saying that, us asking for these things does not waive our right to appeal a final judgment, etc., etc. And here is the statutory grounds for remittiture or reduction of the amount of a verdict. And here's what they're saying that the court should take into consideration when deciding whether or not to reduce the jury award. The statute lists the following factors to consider. 1, whether the amount awarded is indicative of prejudice, passion, or corruption on the part of the trier of fact. B, whether it appears that the trier of fact ignored the evidence in reaching a verdict or misconceived the merits of the case relating to the amounts of damages recoverable. C, or 3, whether the trier of fact, so that's the jury in this case, took improper elements of damages into account or arrived at the amount of damages by speculation and conjecture. 4, whether the amount awarded bears a reasonable relation to the amount of damages proved and the injury suffered. And 5, whether the amount awarded is supported by the evidence and is such that it could be adduced in a logical manner by reasonable persons. How's everybody doing out there in YouTube land? Hippo lover? Is that the hippo lover? Are you the one who lives with your husband? Or did somebody steal your username? I'm flattered. I'm flattered that you guys are listening to me because, we didn't we didn't make it into any of the court papers, and we're kind of happy about that. And I'm really sorry actually that you did make it into the court papers. with your real name and everything. And I think that was kind of sleazy. And I notice now that the court files have been redacted, but too little too late, in my opinion. I hope that you are not being in any way bullied or sought out, or people are coming for you. Just don't read Reddit, I guess. I don't read Reddit really, but I've heard that they're not real nice over there in Reddit. I heard that that's where the defense got a lot of their information. Oh, thank you, Hippo Lover, for your super sticker. I appreciate you so much. And Susan Agnello, thank you as well for your super sticker. Oh, you're listening too? Good. Listening and chatting. Hippo Lover. Paul says, at the next intersection, make a right. Yes, Sarah says, this is wasting trees. And here's why they think they should get a renewed motion for directed verdict of punitive damages. The standard for granting a directed verdict on a claim for punitive damages is essentially the same as for any other claim. The differences arise not so much in the overall standard, but rather in the quantum of evidence necessary for the issue to reach the jury, because entitlement to punitive damages must be proven by clear and convincing evidence. The evidence also needs to create a jury question on the high bars set by Section 768.72 Florida statutes. The employee's conduct must first meet these standards. Well, I guess this is quoting another case. And here's what's required to be awarded punitive damages. Intentional misconduct means that the defendant had actual knowledge of the wrongfulness of the conduct and the high probability that injury or damage to the claimant would result, and despite that knowledge, intentionally pursued that course of conduct resulting in injury or damages. Or gross negligence, which means under the statute and the case law, that the defendant's conduct was so reckless or wanting in care that it constituted a conscious disregard or indifference to the life, safety, or rights of persons exposed to such conduct. In this case, they say, the Kowalski case, the torts are not matters of negligence. They are intentional torts of false imprisonment and battery. That is true. Thus, although the plaintiffs actually pleaded none of these statutory elements, the awards in this case should not have been allowed to be based on gross negligence as compared to intentional misconduct. They may be right about that on the law as well. But this court ruled otherwise. Even under the gross negligence standard, the defendant submits that it is entitled to relief on its renewed motions for directed verdict. It is also entitled to a directed verdict because there was no evidence that a director or officer of J Hatch committed any of the acts specified in Section 768.72 sub 3 Florida statutes. The purported, quote, manager involved in one of the claims was merely employed as a risk manager in a risk management department. Okay, so merely employed as a risk manager, so that's not really an important job at the hospital? That's a ridiculous statement to put in there. Plaintiffs presented no evidence of that person's job description or authority within the corporation. He just merely worked in risk management. That's all. He just managed risk, but he wasn't really important. Then they go on to say about, and this is all with regard to punitive damages, the same thing that we discussed in the earlier standards, that they should get a new trial because they need to review it. Similar to other claims, and award of damages has been so reviewed because of the high statutory bars and the clear and convincing standard of proof. They're also saying that with regard to the punitive damages, they should get a motion for a new trial should be granted based on errors occurring during the trial. And we're going to get into more of that with each claim. And a motion for the new trial should also be granted in their opinion because, in their opinion, the punitive damages were excessive. It says here that a trial court may order a new trial on excessive awards of punitive damages if there was an impropriety of the verdict or an independent determination that the jury was influenced by considerations outside the record, like YouTubers. like Google searching Dr. Kirkpatrick's RSD Foundation, because there's no way that creature comforts was ever mentioned during the trial. And we know that it was because we saw the receipts. And we also heard it when we were sitting home watching the trial. So we heard it too. In this case, among other reasons, the impropriety in the amount of the compensatory damages affects all of the claims for punitive damages. Then they talk about how they should be able to have the punitive damages reduced, but they say it may be complicated by the fact that this court allowed the unpleaded specific intent issue to be tried in a mini trial during the second phase of the bifurcated proceeding, which defendant submits as a clear error of law and a violation of due process. That said, when a trial court reviews an award of punitive damages under Section 768.74, the statute plainly requires that the amount awarded must bear a reasonable relation to the amount of damages proved and the injury suffered. This reasonable relation requirement is not measured against an excessive award of compensatory damages. It must be related to the amount of damages actually proved and the injury actually suffered. And they get into due process. In the U.S. Supreme Court requires courts to consider 3 guideposts in determining whether the award of punitive damages is unconstitutionally excessive. 1, the degree of reprehensibility of the defendant's misconduct. Well, I am going to come to the chat for a minute, because I'm pretty sure that everyone in here agrees that it was just about as reprehensible as it can get. Reprehensible? What say you, my friends? What say you? Oh, thank you, Valor Warrior. Love listening to me read, especially after a long emotional day. So relaxing and a comforting voice. Thank you. Thank you. Maybe I should start like an ASMR channel, and I can just read legal documents and I can put you all to sleep. Except sometimes I get fired up, and then I really get a little too angry while I'm reading them, and the actor in me comes out and I start, really acting this out. Deirdre said, I think Dr. Sally Smith had a hero complex. She got a rush when she was the hero. There was a NICU nurse that was a grief vampire. She killed babes. I think SS is the same kind of bad. I think that's an excellent observation. And perhaps Valor Warriors is very reprehensible. I don't know if juror number 1 is still here. Oh, hi, Hippo Lover. But I don't even really want him to answer any questions, but I'm curious about whether the jurors knew that after they came back with their initial verdict that they were going to go back for another phase. I don't think they were told that. Is that a surprise? Because I don't know, but after sitting there for 9 weeks, I would have been like, what? wait, we're not done? We come out, we're all dressed up, we're like ready to go, and we're not done? I think, in my opinion, they should have told them that there was going to be another phase. And then they sort of jammed that punitive damages phase into the afternoon. I mean, it was crazy that it was, it came to verdict and the reading of the verdict, and the reading of the verdict took a long time. And then it was kind of like, okay, go to lunch. And then when you come back, we're going to have a whole nother mini trial on punitives. So Melanie Great Voice. That's a cool nickname. Thanks. That NICU nurse is British and a gaslighter. We've been covering a lot of gaslighters lately. A lot of guessing. Tiny Tina, do the defense have anything at all that doesn't sound like whining because they lost? Yeah, please don't answer that, juror 1. I'm just thinking out loud. Although, if we were all listening to the trial. So yeah, Nancy, you think the same thing, but we were listening to it. And I think that it was discussed outside the presence of the jury that they didn't tell them, and they were going to have to tell them. Oh, Deb, what do you mean? What a day for me to be listening and without being able to chat. Hello, Deb Galloway. Hello. Hello. Yeah, we found the plant. Hey, Sarah, we found the plant in chat on day 2. She's blocked. We blocked her butt quick. We know exactly. Oh, and her name is a flower. You guys know who I'm talking about, right? We you know, early you got to get up to fool us around here in this chat. My mods are on it. On it. All right, getting back into the due process clause of the 14th Amendment. They're saying it limits the amount of punitive damage that may constitutionally be imposed on a defendant. Oh, that we already went over this. The degree of reprehensibility, the disparity between the actual or potential harms suffered by the plaintiff and the punitive damage award, and the difference between the punitive damages awarded by the jury and the civil penalties authorized or imposed in comparable cases. All right. Then they get into the meat of it, and they're saying, oh, well, first they're saying, in this case, the $50 million in punitive damages bears no relationship to the injuries or the damages actually proved to be related to the false imprisonments and the battery and violates due process. Similar to a motion for remittiture for compensatory damages, this motion is only requested after the denial of motions for directed verdict or new trial. The defendant intends to appeal the denial of those orders as adverse rulings from any final judgment or new trial order entered on a motion for remittiture of punitive damages. And I'm telling you, that is very common. It's always done. Nothing crazy or strange about that. But let's go to the chat for a moment. See how all of you are doing. How's everybody doing tonight? Sharon says, I felt bad for the jurors when they thought the verdict was in, then they had to go back and assess damages. I bet they wanted to go home and be finished already. 9 long weeks of sacrifice. Yes. Juror number 1, do not say a thing. Do not say a word. Just listen. Just listen to my ASMR voice. Is it ASMR or AMSR? I don't even know what that stands for. But I think there's people that like throw bottles downstairs and it's supposed to be comforting to listen to the bottles go bouncing down the stairs. I don't know. Never listened to it. Sarah Adams is your hero. Hello, Susan. Oh my gosh, favorite channel. I could listen to you all day. I'm just shorting your name to Susan because Sassy Southern Susan is a tongue twister. LB says this chat rocks. Thank you too. Yes, it is, Sarah. So funny. That is Seinfeld. You're right. You are right. I mean, the jury instructions did mention it, but not sure how clear it would be to someone who didn't understand the process. Yes. And I will tell you that with over 30 years as a lawyer, I was confused by a lot of things that went on during this trial. I was confused by the verdict sheet. I was confused by the jury instructions. And I have been doing this for over 30 years. And I went to law school and I passed the bar. So I can't even imagine what it would have been like for someone who didn't have that kind of background sitting there if I was completely confused as well. Hi, Susan. This whole situation is beyond disheartening, especially when you are living with a child that is unfortunately a victim of doctor gaslighting, doctors club protecting each other's, you know what. Yeah. Yeah, that's why it can be very, very hard in medical malpractice cases to find an expert witness doctor that's willing to testify against other doctors. And you're going to see that when we get into, they're going to start bashing Dr. Newberger, calling him elderly and old, and it gets worse. The adjectives that they use for him get worse. Janelle says, I want to know ultimately what the jury thought when Mr. Shapiro said, why are you so angry with us? Yeah, I know. It is. It was very draining. It's been 9 weeks and this is still dragging on. It's still dragging on. Here we go. It's going to go on a little bit longer because we have some more to get through here. Let's see. Should I be bigger and that be smaller? I mean, are a lot of you trying to read this on the screen? Oh, hey, Sarah. Thank you. Thanks. I can't really check my mail while I'm doing this, but I will in a little bit. But thank you for your super sticker. Oh, BL Blazy says ASMR. Okay, so it's ASMR. Used to be relaxing rain waves etc. Audio. I listen to rain sounds at night on Spotify when I go to sleep, and it puts me to sleep like every time. I love the rain sounds. I can't sleep without it now. Kind of addicted to it. All right, here we go. Issues affecting all claims. This court erred in the application of Chapter 39 immunity affecting nearly every claim in the case. We were all confused by Chapter 39. Chapter 39 in Florida grants immunity to anyone who is a mandated reporter that reports child abuse for any results therefrom. Sally Smith, Chapter 9 immunity, 39 immunity, they're going to claim. They say prior to trial, this court granted a summary judgment, I should say a summary judgment motion, determining that the defendant had statutory immunity under Section 39 Florida statutes for reporting the claim to DCF for the investigation of that claim and DCF's decision to pursue a dependency proceeding against Beata and Jack Kowalski. In exchange for obeying this statute and for cooperating in good faith with both the defendants, the dependency court, and DCF, the defendant was entitled to immunity for any act authorized or required by Chapter 39. I'm not a Chapter 39 expert. I don't even practice in Florida. I'm a New York-based attorney. So I can't get into the nuances of Chapter 39 with you and tell you whether I think they're correct, but let's hear what their argument is anyway. They're saying that they should have immunity for these acts. Those acts included keeping Maya in the defendant's hospital even after she was ready for discharge in October. Those acts included waiting for a transfer order to a facility that was better equipped and staffed to provide the therapies that Maya needed, and such order never arrived. The defendant could not transfer Maya to a hospital that provided K infusions because none were known to exist, and the dependency court did not enter any order authorizing that treatment. The immunity should have extended to complying in good faith with the multiple orders entered by the dependency court regarding visitation and communications. But this court interpreted the protection given to the hospital very narrowly and allowed negligence claims as well as intentional torts to be litigated for actions for which the defendant was entitled to immunity. To be clear, the defendant is not maintaining that statutory immunity would give it a free pass to torture a child or place a child in a dungeon. Really? Hunta? Really? Place a child in a dungeon? This is where it's going to get a little hyperbolic and a little trigger. I'm just going to trigger warn you because I think it's in poor form. Not that it's going to be unduly graphic in any way, but it's not something I would say. But acts like placing Maya Kowalski in an ordinary hospital room to be video recorded to confirm whether her actions are consistent with CRPS or are instead consistent with a psychological problem that may have been caused or enhanced by her mother's behavior should be acts for which the defendant has immunity. It's their story and they're sticking to it. So too should the act of keeping the child in the hospital when the defendant expects that the dependency proceeding, based on the investigation commenced by its hotline report, will be filed imminently. Oh, so they're saying, we expected that they were going to enter their they were going to enter their order right away. So for the first 6 days that she was in our custody, when she had the freedom to leave and we told her parents they couldn't, we should receive immunity for that because we relied on, we thought that the dependency court was going to issue an order imminently. Photographs taken to document her skin condition before she left for court, where her skin could be affected, should be immune. The defendant is not claiming that a typical malpractice claim for treatment in a hospital should be exempt. But after the entry of the shelter order, the parents' right to make medical decisions did not extend to demanding K infusions for their daughter at the hospital when the prior infusions were a major component of the reason the DCF filed its proceeding. The Kowalskis and their attorneys could have filed an emergency petition to try to convince the dependency court that it should authorize such treatments, and then the child could have been transported to Dr. Hannah's office for that treatment, but they did not. Oh, okay. So now you're going to shift the financial burden back onto the parents of the child whose parental rights were stripped because of Sally Smith's false allegations of Munchausen when you actually had the CRPS diagnosis in your computer system because she had her port installed at your hospital. Yeah, that's weak. Weak. IMO, TBH. But they did not. They sold their second home to afford the attorney to even proceed with those proceedings. And there's little reason to believe that a judge considering evidence that would have established that the standard treatment for CRPS in hospitals across America did not include high dosage K infusions would have granted that motion. Oh, okay. So they're saying, well, they didn't make the motion, but we really don't think the judge would have granted it anyway. So, oh well. A judge learning that this process was only being performed by a limited group of physicians as more as a matter of experimentation than as a treatment modality acceptable and appropriate by reasonably prudent similar physicians. I know I'm squinting. Somebody said to me, yeah, you're squinting. I'm like, yeah, because the font is like this big, and unless I full screen it on my screen, I can't read the chat. Deal with it. A judge learning that this process was only being performed by a limited group of physicians more as a matter of experimentation than as a treatment modality acceptable and appropriate by reasonably prudent similar healthcare providers was very unlikely to resume high dosage K infusions. Thus, the medical negligence claim in this specific case is a claim for which defendants should have immunity because any ultimate decision to reintroduce that treatment following the shelter order was a matter for the dependency court. The claims for intentional infliction of emotional distress would not be claims for which the defendant would be entitled to immunity if proven. So they're agreeing that if intentional infliction of emotional distress is proven, they don't get immunity for that. But they're saying the problem in this case is that conduct interrelated with or heavily affected by the rules and regulations imposed by the dependency court, and this is DCR, but it should say DCF, was often used to confuse the jury and allow the admission of evidence that was not extreme and outrageous conduct intolerable in a civilized community. In my opinion, that's a question of fact for the jury. So whether it was extreme and outrageous conduct intolerable in a civilized community, it's a question for the jury. On September 8th, just before trial, the plaintiffs filed a motion in limine to exclude any mention of the DCF, Chapter 39, and the dependency proceeding at trial. The court denied that motion, but took the position that it would only allow very limited reference to those proceedings. The defendant recognizes and agrees that litigation immunity prevented use of testimony from that case as evidence against a party to prove liability, and likewise agrees the court had discretion to limit extensive discussion of legal arguments and rulings in that case. But the fact that the proceeding existed and had a major impact upon the stress in the family, that the Kowalskis attended multiple hearings that upset them, and the full explanation of the hearing that triggered Beata Kowalski's suicide became off limits after the motion in limine was heard. This court, under the urging of the plaintiffs, transformed a statute giving the defendant a shield of immunity into a sword. Oh, I use that all the time. You can't use it as a shield and a sword. Oh, I think somebody's listening to me. That was repeatedly used by plaintiffs' counsel. Objection, Chapter 39, was used to prevent the jury hearing relevant and necessary testimony and evidence, including, for example, the December report of Dr. Sally Smith. The defendant believes this transcript will show instances where the court limited evidence based on Chapter 39 on its own motion. I would have liked to see that report of Sally Smith. The court repeated, or did we see it? Did we find it and go over it? I can't even recall at this moment. The court repeatedly told the jury that the defendant was not responsible for Maya Kowalski's long stay in the hospital, but plaintiffs repeatedly presented witnesses or made statements in front of the jury about the child being trapped in the hospital. Maya Kowalski, both in court and on the telephone recordings with her mother, was explaining how desperately she wanted to go home to her mother. The jury clearly did not understand the nuances of immunity under the instructions given by the court. The limitations placed on this issue made it impossible for the defendant to keep the jury from being enraged about events and circumstances over which the defendant had no control and no legal responsibility. This is most evident in the three claims for intentional infliction of emotional distress, but it also impacted the claims for false imprisonment and battery. Given the size of the monetary awards, it appears to have affected all of the claims. Defendant submits that this court erred in failing to grant broader immunity to this defendant and in failing to permit a fuller explanation from the witnesses, including the DCF witnesses, about that lawsuit and its impact on the family. This error, they claim, warrants a new trial at a minimum. This error does not impact this one case alone, especially in a case where a hospital has recognized, even before the entry of a shelter order, that a child needs specialized rehabilitation better available at other hospitals and that the child is ready for transfer. It's cooperation with the dependency court that never enters an order allowing it to transfer the child to a hospital with a specialized inpatient or outpatient program during the following 3 months should not subject it to the risk of a judgment. Certainly should not risk the possibility of the huge judgment the jury's verdict would require in this case. If this judgment is not set aside, oh, here they go. Here they go again with this is going to have a chilling effect on mandated reporters. Like it's going to have a chilling effect on jury duty, what you guys did. I agree with that, but hold on. I need chapstick. If this judgment is not set aside, no hospital in Florida will be willing to keep a child in DCF custody in its facility once the child is ready to be discharged to foster care. The hospitals will have little option but to seek an order from the dependency court transferring the child into a DCF medical foster care facility operated under the umbrella of the state's sovereign immunity. I need to check in with you, my peeps, because I had to turn the chat small. Right, Maddie? Transfer you were pushing for, Hunter. Out of state, right? Pushing for out of state even after Beata was gone. Kept pushing, kept pushing, kept pushing. Scott said, no, the hospitals will do their jobs correctly. Good point. PB&J says, I'm a mandated reporter and it will have absolutely no effect on me or me reporting anything. Yeah, Cat Lady, why would a hospital keep someone who's ready to be released? They're saying because they were under court order to do so. That is what they're saying. Tracy, how is not keeping a child in a hospital when they're ready to go home something people would want? And this crap strains credulity. I know. You weren't here last night, but I said you had that idea for the T-shirt. It strains credulity. It's a word that just does not get enough play. Credulity. All right. Now, this is an interesting argument, okay? Because I thought about this when Anderson was making this argument. I don't know how I feel about it. They're saying the court erred in allowing the plaintiff's attorney to make the massive request for damages generated by the per hour per component closing argument, which affected every claim in this case. The defendant filed a motion to limit the use of an improper closing argument based on a method that deceptively allowed plaintiff's counsel to suggest awards as reasonable awards when they are many times higher than the maximum legal range in which the jury was actually free to operate. By dividing the damages into hourly amounts for components of the overall award of non-economic damages and employing a period of 8 hours or longer for each day of a plaintiff's lifetime, this method can make an award exponentially higher than is appropriate. And in this case, plaintiff's counsel often used 12 to 14 hours per day at a rate of $100 an hour to present with a straight face aggregate damages many times higher than the amount a reasonable jury would normally award. For Maya Kowalski's claim in the aggregate, plaintiff's counsel divided non-economic damages into past and future claims for pain and suffering and for mental anguish and for loss of the capacity to enjoy life. These separate claims were then given an hourly value of $100 per hour, which resulted in a daily total damage, undisclosed to the jury, of $8,400 per day for a lifespan of 70.42 years. That's the life expectancy based on the life expectancy tables that insurance companies use. life insurance companies anyway. The aggregate amount requested by plaintiff's counsel resulted in amounts spread among the various claims for her that totaled $64,496,000 just for non-economic damages. Without considering income on that amount, meaning interest that it would bear in an interest-bearing account, that award would pay $915,000, $876,000 per year, or more than $2,500 per day for every day from the time of this event until she dies. Even more shocking, given Mr. Kowalski's life expectancy, plaintiff's counsel recommended $2,700 per day for Mr. Kowalski for a total of $26 million and change, but the jury gave him $50 million. That is more than $5,200 per day, and it too is awarded in a lump sum that will produce extensive income over his lifetime. So in New York, I don't know that we're allowed to make those arguments in closing, the per hour argument. So if that is improper under the law, and the judge still allowed it, because I think they did object to that during closing. They made a lot of objections during closings, and I do not like objections during closings. But if that is an improper argument, and it has been held that is an improper way to ask for damages in a personal injury trial or a med mal case in Florida, they may have a point. But unless there's case law on that, and I don't really see any, but not yet, we'll see. Within about an hour of the commencement of deliberations, despite the fact that the jury needed to review an immense collection of exhibits introduced into evidence but not shown by either party during the trial, under the leadership of juror number one, blaming juror number one again, the jury was already asking the court to provide the documents and testimony that were used to support the huge aggregate award. They wanted to hear what the economists had to say because they were told that they were going to get those calculations and PowerPoint and or table, and they didn't have them. And they were looking for them. There's nothing wrong with that. Ultimately, the jury followed the argument of plaintiff's counsel instead of the law and entered yes for every liability box. Well, I don't know about that. That's not just 'cause they entered yes for every liability box doesn't mean they weren't following the law, but okay. And awarded damage amounts that are patently excessive and irrational when examined claim by claim. The award for Mr. Kowalski for past medical bills totaled $1.5 million and change, which clearly demonstrated that the jury duplicated damages. The award of $5 million for insurance fraud when plaintiff's counsel suggested $1 and has even given this court a proposed judgment for only $1. Okay, so that's interesting. So the plaintiff has conceded that the $5 million awarded was excessive and they're willing to accept $1. They've already made one concession. Demonstrates that the jury was totally lost in passion and prejudice when considering the issues in this case. Simply put, this method was an artifice that misled the jury. Jury influenced by prejudice, again with the tongue twisters, prejudice and passion has produced a verdict so unreliable that a new trial is needed on all issues. Then they get into the negligent training claims, and they're saying that the decision to grant the defendant's motion for directed verdict on the negligent training claim only at the very end of the trial allowed the jury to be confused and misled by the irrelevant evidence that impacted many of the claims in this case. Well, look, it's just the way it works sometimes. Sometimes you get a directed verdict at the end of all the evidence, at which the point the jury is instructed to disregard all of that evidence. And we have to believe that they're taking their oath seriously and they'll disregard it. It's like asking an improper question of your witness, them barreling through the objection and getting it out there, something that you want out there. And then, they move to strike it and the judge says to the jury, just disregard that last statement. They're supposed to disregard it, but sometimes the cat's out of the bag. That's just trial. That's the way it goes. At the beginning of the trial, Maya Kowalski also had a claim for negligent training. This claim, which was not eliminated until a directed verdict immediately before closing arguments, allowed the jury to hear extensive, confusing, and ultimately irrelevant evidence that misled the jury and prejudiced the defendant. This issue is addressed in greater detail in the motions directed to Count 8, medical negligence, but this legal theory in Count 14C never should have survived to affect even the first day of trial. At the end of the plaintiff's case, the defendant was entitled to a directed verdict. The claim was presented as a common law claim of negligent training by a hospital that is a statutory healthcare provider for training given to doctors and nurses who are statutory healthcare providers. It could never have been a common law simple negligence theory. This smorgasbord approach to pleading produced a confusing and open-ended, unauthorized legal theory that allowed an extensive amount of irrelevant evidence about negligence on the part of the management and the staff of the hospital to be presented to the jury. So what they are going to say here is that almost everything that Dr. Corcoran testified to should not have been let in because the negligent training argument claim was thrown out at the end of the case, and therefore Dr. Corcoran's testimony should not have been allowed. This evidence was then used by plaintiff's counsel as if it were evidence of intentional acts of extreme and outrageous conduct, and as if it were relevant to proving the distinctly different conduct by managing agent necessary for corporate punitive damages. This court correctly, albeit belatedly, granted a directed verdict on this claim at the very end of the case, but by then the damage had been done, and that damage is reflected throughout the jury's verdict. The error was especially harmful as it relates to Dr. Corcoran's testimony in the plaintiff's case and all that followed him from that testimony in the defendant's case, and even more so in rebuttal. Dr. Corcoran could never have taken the stand on a liability theory unless Count 14C was tried. A theory of management negligence was never a part of the claim for medical negligence. This error requires a new trial for the entire case, or at least for major portions of the claims made by Maya Kowalski and the estate. Checking in with the chat. I love the cupcakes. How do I go? And says you have to join the channel. Hit join. Become a member. Become a member of Melanie Lucilla Cupcakes. The reason that it's called Cupcakes is because there's a little logo up here that says I am not a cupcake. I have a sign on my wall that says, you cannot make everyone happy. You are not a cupcake. I can't make everyone happy because I share my opinions. And a lot of people think I should have no opinions and I should be a neutral channel. But I am a recovering lawyer, a mother of 5, and a working actor. I have all kinds of opinions and I'm not afraid to share them. And we're not afraid to talk about the top topics over here. So hence, I am not a cupcake. Yeah, Maddie said they opened the door. They just don't get it. Risk management, negligence, or non-being. Maddie says they opened the door. They just don't get it. Sassy living. And it is their job during the trial to explain things and events in a way that allows the jury to see your side and then side with you. Maybe they didn't do their job well enough, and then that's on them. Paul says the defendant didn't let their spaghetti cook long enough. And now they're going to say that the grant of additional time to plaintiffs in this case severely prejudiced the defendant. I thought about this during the trial too. And I thought about, okay, they have strict time limits. They've got a hard stop of November 9th. Like the trial had to be done, I think, right, by the 9th or the 10th. And now they're going to give plaintiff more time. I knew the defense was going to complain. I knew it. Now they're going to say it severely prejudiced them. They're going to have to show severe prejudice. After the defendant had carefully used limited time for cross-examination in the plaintiff's case in order to have sufficient time for its own case, this court granted the plaintiff additional time for its case on not one but 2 occasions. Coupled with the inefficient manner in which plaintiff's counsel introduced exhibits and the testimony of witnesses, these extensions placed the court behind on its timeline that required this case to end on November 9th. Yeah, it was November 9th. In the end, the defendant had many hours of time remaining, theoretically, when it rested. The defendant knew it had time, but no remaining days to present more witnesses, or, for example, to prevent several hours of the video from the room on the 7th floor that contained the video and EEG equipment. In retrospect, given that it is clear that the jury did not review exhibits such as the EEG video clips, additional testimony would have been very important in preventing the runaway verdict. So now it's a runaway verdict on compensatory damages and punitive damages. But it also would have forced a mistrial because it would have caused the jury to have no time to deliberate. Yeah, and we were talking about that. The hard stop, I think, was a problem. By taking professional steps to fit this trial into the timeline required by the court, but skewed by the extra time given to the plaintiff, the defendant received an irrational verdict from the jury. It was irrational and runaway, both. It was then compelled to try both a substantive component and the usual damages component of the bifurcated punitive damages claim in an abbreviated mini hearing that resulted in a $50 million award of punitive damages and findings on specific intent that are unsupportable under either of the two optional burdens of proof that this court gave the jury. I wonder if there are any practicing lawyers in the chat from Florida. And if you can tell me whether putting time limits on lawyers is something that is commonly done, because I've never seen it done here. Is that a thing? I mean, in addition to letting the jury ask questions, which we don't do here either. I don't know. I found that odd. The trial should take as long as it's going to take. I mean, both sides are going to say that they've been unfairly prejudiced by having a time limit. And, they accused juror number 1 or his wife, and I can't remember which one, of being concerned about the shot clock. Oh, I guess Hippo lover, I guess it was you that they accused of. You must have been talking to your husband because you knew about the shot clock. We all knew about the shot clock. And the judge said how much time was left, how many times a day. Lynette, after seeing the take care of my case, I'm now afraid to ever take my daughter to the ER, and will definitely try to see her doctor first. It's truly scary how much this case uncovered with the medical field. Yeah. And with DCF, being able to take your parental rights away within a week with false allegations of a psychological disorder of a parent when they're children's hospital. Very scary on a lot of levels. A lot of levels. Valor Warrior, thank you. I've seen it in a few trials in the past 2 years. Okay. Cool. Jenna Rose Depp trial, there were time limits. Okay, that was where was that, in Virginia? Hey, Team Brittany is here. Hello. Hello. Hello, Todd. Who dat? Who dat? Clement. It was a civil trial, so maybe time limits in Florida. A lawyer you know can answer that. I know. He's not here though, is he? He could probably answer that. Maybe it's the judge's discretion. Maybe it depends on the complexity of the case, but my argument would be like, this case was so complex that it needed extra time, needed more time. Ray, you're just a casual trial watcher, though, not a lawyer, and you're such a valued member of this chat as well. I often agree with every single thing you have to say. One Step Beyond says the Florida DCF makes you think the Soviet Union didn't fail, it just moved. And that's the other problem, okay? Because in Pinellas County, Florida, where this happened, it is one of only 6 counties in Florida that are privatized. Their DCF system is privatized. So somebody like Sally Smith, who works for a private company, is not needed unless she's needed, right? They don't make money unless they find abuse. The system is flawed in a lot of ways, but that is one of the major flaws that I see here, is the privatized system. Yes, Cheryl. Alec Murdoch got 27 years for his financial crimes. Yeah, and the speech that he gave at before his sentencing was just an hour of all about me. It was the most narcissistic speech I've ever seen in my life. He did it all. He cried. He talked about pawpaw. It was just, it was cringe. It was cringe to watch. Hi, Emmy. Emmy, it's not uncommon for civil trials here. It's up to the judge. Both sides can request more time if necessary, and the judge always grants. Okay, so I guess you're in Florida. You are in Florida, and it is up to the judge there. All right, cool. All right, so they're going to talk about Dr. Newberger, and they're going to say that Dr. Newberger's deposition testimony was something that also should not have been admitted into evidence or read to the jury because that testimony presented to the jury should have been excluded because it was incredibly prejudicial. And here's why. They've attached his entire transcript, by the way. Did they read his entire transcript during the trial? We didn't. I don't think we covered that day together, but did they read Dr. Newberger's entire transcript or just portions of it? I don't recall, but maybe they'll tell us. They say Dr. Newberger is an elderly physician. Look, elderly. He's an elderly physician. He graduated from medical school in 1966 and he gained his first experience in the Vietnam War. Who's writing this? A 20-something? He's a general pediatrician who's clearly qualified to testify about child abuse issues. When younger, he taught at Harvard Medical School and served on the staff at the Boston Children's Hospital. But he retired at the end of 1999 and never had an actual pediatric practice. He no longer examines more than one child a month, and the last child that he actually treated was his own grandchild. He is licensed in Florida only for purposes as serving as a criminal prosecution expert. He's not board certified in the subspecialty of child abuse. Okay, well, not a lot of people are. In fact, Dr. Sally Smith was one of the first people to be board certified for the subspecialty of child abuse because it is a very, very new subspecialty of medicine. But he was grandfathered and decided, okay, he was grandfathered in. He's not board certified, but he was grandfathered in. Since 1989, his consultations in child abuse pediatrics have been his sustaining source of income. Okay. Same goes for Sally Smith. To be clear, the defendant does not question Dr. Newberger's qualifications to express opinions despite his age and limited recent experience. I'm getting offended now. He would have been well qualified to testify for Beata Kowalski had she chosen not to commit suicide and instead had gone to trial in February 2017 in the dependency court. But the standard of care issues in this case concerning the healthcare providers at Johns Hopkins All Children's Hospital are not and never have been issues of child abuse. After the plaintiff withdrew any claim concerning Munchausen by proxy, the subject of child abuse had little or no relevance in this case. But Dr. Newberger was allowed to become a jack-of-all-trades expert who opined on the unlawful acts and conspiracy of the doctors at Johns Hopkins All Children's Hospital, a conspiracy headed up by Dr. Sally Smith. He reached these opinions by reading depositions and records from the hospital. He was the equivalent of an expert juror in a criminal proceeding against the hospital staff. Court let this testimony into evidence over objection. It says here that, for example, the court admitted the following testimony. The portion of the first sentence in italics is the only portion of this testimony from the deposition that the court decided to exclude. It is in his deposition, but not the trial transcript. The evidence of multiple references to team decisions and abdicating personal responsibility and defer in virtually all principal diagnostic medical judgments and decisions to Sally Smith was, oh, and then they took out the part that says was an intentional act which was both wanton and malicious. In addition to this opinion with regard to team decisions, I intend to opine that this so-called team represented a group of individuals who together agreed to commit an unlawful act and to harm other individuals. The witness's intention to opine was fulfilled when this court admitted this testimony. The court allowed Dr. Newberger to describe the medical team, including Dr. Sally Smith, as conspirators acting on the basis of a flimsy motion, performing acts preposterously conceived and cruelly executed. The separation test that these conspirators proposed was based on a flimsy notion that this child could be hospitalized and weaned from some of her treatments, having her port removed to administer K, and for that matter, immune serum globulin for her serious asthma attacks and medications that allayed the pain of her neuropathic syndrome, pain which was excruciating. But Elliot specially proposed continuing the weaning from gabapentin, which is one of the neuropathic pain medications. This separation test, in my opinion, was preposterously conceived and cruelly executed. That was Dr. Newberger's testimony. They say, this is an opinion from a doctor qualified to render child abuse opinions who is challenging the work of a board-certified anesthesiologist, pain management physician concerning medical decisions well beyond the expertise he had even in 1999. Okay, well, that's why we call it Battle of the Experts. Remember, we did that whole show where we put Dr. Corcoran's testimony up against that Dr. Anderson's testimony? Battle of the Experts. Welcome to trials, my friends. Welcome to trials. And his opinion is couched in terms that Dr. Elliot did this as a separation test, preposterously conceived and cruelly executed. Over objection, this court allowed the jury to hear this incredibly prejudicial testimony. Okay, just because you don't like it, just because it's bad for your case, doesn't make it under the law incredibly prejudicial. It might, but it might not. Moreover, it should be observed that this elderly doctor, again, he's an elderly doctor, was also very confused about the basic facts expressed in his own opinion. This child's port was never removed in the hospital. Beata Kowalski refused to follow the advice of the doctors who were actually treating Maya Kowalski. It was not Dr. Smith who asked her to consent to its removal. And Maya Kowalski was not admitted to the hospital for serious asthma attacks in October of 2016. A third example is Dr. Newberger's ability to testify that, quote, she's not faking it based on all of the CRPS symptomology that's been documented at this very time, which Smith couldn't get her head around or wouldn't. They say he's not an expert on CRPS. He's providing an opinion about Dr. Smith's opinions as the CPT leader that were in her report, which the court excluded from evidence. Those opinions are matters for which she has immunity, and this court ruled that the defendant cannot be liable for her investigation. Okay, so we didn't do it. She did it. We don't think she really did anything wrong, but if she did it, if she did something wrong, it's not on us. And most of all, he's giving an expert opinion on her credibility about whether she is faking behavior that he never witnessed himself. Although there are more examples in his testimony, as also discussed later in the section of medical negligence, a final example demonstrates the breadth of the prejudice resulting from the testimony the jury was allowed to hear. Quote, with regard to the impact on this family of Dr. Smith's and the other Johns Hopkins All Children's Hospital workers, they have been more deeply informed with regard to the trauma suffered by the girl and her father with regard to their impact in propelling the mother's taking her own life with regard to the following impacts on the child of the trauma, which have produced an acute and concerning medical set of consequences that derive directly, in my opinion, from the malfeasance of the staff of the hospital. Oh, here we go again. This elderly child abuse expert was allowed to testify that doctors far outside his specialty committed malfeasance and their impact in propelling Beata Kowalski to commit suicide. This is not expert testimony. It is plaintiff's closing argument for the claim of intentional infliction of emotional distress caused by the death of suicide. His expert testimony without factual basis made Dr. Sally Smith the head of the conspiracy, proven by her December report, which was prepared and filed after virtually all treatment decisions had been made. This group of conspirators committed acts that propelled Beata Kowalski to commit suicide. There's no factual basis in this record to support any of this conspiracy theory, only this clearly inadmissible opinion that thoroughly intermingles and conflates the Chapter 39 proceeding with this lawsuit. The magnitude of this error is hard to measure, but the jury clearly measured it in dollars. Well, that's like the first thing I agree with them about in this motion. This error warrants a new trial on every claim. Okay, just how old is Dr. Methuselah? He graduated from medical school in 1966. So you tell me. You do the math on that one. I mean, he's in his 80s, I guess, right? I'm going to come to the chat for a minute. Rachel Ann. So basically, they didn't do their job when he was testifying to refute or discredit his testimony to the jury. And they are whining for a redo. Seriously, defense? Well, they read his deposition testimony in. He didn't come in live. So that's the risk that you run when you allow deposition testimony to be read into evidence. Defense should have subpoenaed him to come in and testify, but I guess they didn't. I mean, I'm going to assume that he's still alive because they didn't say that he's deceased. I mean, they would have, they would have thrown that in there, right? 100%. What say you? Susan Schaefer, thank you. He stated in his deposition that he was one of the group that created the field of medical child abuse. Well, there you go. Guy invented the subspecialty. So they didn't make him become board certified because he invented it. Guess they forgot to say that. Couldn't they have put a witness to better disqualify the read testimony, says Rachel Ann. They must have had their own expert countering his expert testimony. Oh, Armand, Dr. Anderson said yesterday that Dr. N has a serious medical condition. Oh, I'm so sorry. Okay, Gamer.go, thank you. The elderly doctor is currently alive, but undergoing a health crisis, per Anderson. TJ Bits says he was an amazing witness from his red depot and video depot. Everyone says, okay, he had. Scott's going to be a bus monitor to and from the courthouse. I think he'd be a great bus monitor. Yeah, PB&J, like I said, I know a thoracic surgeon who's 86 years old and still working. Looks to be in their 50s, memory is sharp, and hands as steady as 20-year-olds. Yeah, doctors don't retire. Rarely. Hi, Melaine. Hi, Melaine. Thanks for joining. Okay. All right. Oh, their expert was Crane. Okay, so the opposing expert to Neuberger was Crane. Says the cat lady. Maddie says he thought the invention of this accreditation would cause the same issues we are seeing with Smith. Yeah. Yeah. People want to monetize it, right? Can't make any money working for the county. Oh, boy. Oh, boy. That Crane, KL says that Crane kick was ineffective. Right. Back to the papers. If you have any questions, just hang on to them. Now they are talking about motions for the intentional tort claims of Maya Kowalski. At the end of the trial, Maya Kowalski had 4 claims that were submitted to the jury that were intentional tort claims: false imprisonment, battery, medical negligence, and intentional infliction of emotional distress. Those claims overlapped repeatedly concerning both the evidence, reliability, and damages. The court twice told the jury in the jury instructions that although these claims have been tried together, each is separate from the other, and each party is entitled to have you separately consider each claim as it affects that party. Therefore, in your deliberations, you should consider the evidence as it relates to each claim separately, as you would have had each claim tried separately before you. It also reminded the jury not to let bias, sympathy, or prejudice influence its decision. The court provided an instruction on non-duplication of damages, but over defense's objections, it often did not explain that non-economic damages could not be duplicated. In the aggregate for these claims, the jury awarded Maya Kowalski $93 million and change and another $50 million in punitive damages. It awarded Mr. Kowalski as her parent $1.5 million and change for the medical expenses in the past and for approximately 1 month into the future. This verdict, both as to liability and damages, is the product of plaintiff's strategy to create sympathy for Maya that would overcome the law to place responsibility on this defendant for Dr. Sally Smith, the DCF, and the court system for taking her away from her mother, and on the improper approach to an aggregate award of damages merely split among all the claims based on the aggregate per hour per component of damage calculations. Okay, now we're getting to some facts. So buckle up for the facts, and they're going to say why these facts do not justify these monetary awards in their opinion. First, false imprisonment. They're saying, and this is true, for the 3 periods of alleged false imprisonment, the jury awarded a total of $25 million and change in compensatory and $50 million in punitive damages, which included the battery involved in taking photographs of Maya Kowalski on January 6th. First, they're talking about the claim of false imprisonment from October 7th to 13th. They say, this claim involves the decision of the doctors at Johns Hopkins to keep Maya Kowalski in the emergency room or the PICU for approximately 6 days at the beginning of her hospitalization. It is undisputed that Mr. Kowalski brought her to the emergency room on the instruction of Dr. Hannah. She was not cleared to leave the intensive care unit and go to the 7th floor until after this window of time. The plaintiff's theory of this claim is that Beata Kowalski wanted to take Maya Kowalski home from the hospital during this period, and Mr. Kowalski agreed with her. The family had no arrangements to transfer Maya to another hospital. Beata was insisting that her daughter be infused with K at levels that the physicians at Johns Hopkins All Children's Hospital were not aware had ever been used before in any U.S. hospital that were not authorized to use by the hospital's protocol on K or any existing recognized standard of treatment within their profession, and when Dr. Hannah had sent her to the emergency room following similar infusions. There's no evidence in the record that any hospital in the U.S. would have infused Maya at the requested levels in this situation. None of plaintiff's experts claim that any hospital would have performed such an infusion. The plaintiff's theory is that the doctors were unreasonable and unwarranted in failing to roll Maya out of the intensive care unit in her wheelchair and place her in her mother's car to take her home at 1 or more times during this period. Her mother was a nurse infusionist, and Maya had a port installed in her body to allow for easy infusion. It was disputed whether the doctors or some unidentified security guard threatened to arrest the parents if they removed their daughter from the hospital. It is undisputed. So that's disputed. It is undisputed that the doctors contacted Dr. Sally Smith about the situation. Dr. Smith had staff privileges at the hospital and was also known to be the board-certified pediatrician in charge of the state's CPT team in this zone. She had expertise in medical child abuse and the factors to consider when deciding to report a matter to the abuse hotline. After consulting with her, the defendant made 2 calls to report possible abuse to the hotline. The second call was when Beata was apparently wanting to take her daughter home, and DCF acted on that call. Oh, interesting, because they don't mention the first call, because the first call that was made, after that first call, they confirmed the diagnosis of CRPS with, I think, Dr. Kirkpatrick. They dismissed that complaint. But they say the second call was when Beata was apparently wanting to take her daughter home, and DCF acted on that call. Yeah, because they didn't listen to the first call. Yeah, and thank you, Rachel. And the first one was declined because the mom was following doctor's orders, and she had a confirmed diagnosis of CRPS, which was actually in the computer at the hospital. Right? Right. Dr. Smith conducted the investigation for DCF during this period, and the hospital staff had a duty to cooperate with the investigation. Okay, so it's not our fault. We had a duty. Sally Smith has immunity. Nobody's to blame. That's their argument. The defendant is immune for those actions. Dr. Smith concluded there was a basis for DCF dependency proceeding, and the lawyers for DCF agreed. They filed the proceeding and obtained the shelter order effective at 2 a.m. on October 13th of 2016. And what did we see outside the presence of the jury during Sally Smith's proffer? Not my job to put medical records confirming a diagnosis of CRPS in the court record. That's their attorney's job. Again, putting a financial burden on the parents. How about you give the court the whole freaking story? How about that? Maya Kowalski's testimony was that her memories of this period were limited. She did not like the clock in the room, and one nurse apparently did a transfer from one bed to another. That was rough. Oh, is that what you guys are talking about when they say she was dropped? She may have been dropped in this move, but there's no evidence of any injury or requiring treatment. She's already in the hospital. Indeed, there's no evidence that she sustained any physical injury from this imprisonment. There may be evidence of claimed medical negligence during this period due to the unwillingness of the doctors to accept the diagnosis of CRPS as definitive and to begin treatment with a K infusion. At a very high dosage, the doctors had no knowledge had ever been given to any patient, but that is not part of the intentional tort of false imprisonment and is a claim for which the defendant should have Chapter 39 immunity, as explained earlier. The defendant did not move for a directed verdict at the end of plaintiff's case because the only evidence on this claim was provided by Mr. Kowalski and, to a limited extent, by Maya. Because false imprisonment requires a plaintiff to establish that imprisonment is unwarranted and unreasonable, those factors could at least be inferred from Mr. Kowalski's testimony. So they're saying we didn't move for a directed verdict after plaintiff's close of case because we knew it wouldn't be granted. But during the defendant's case, evidence including an email from Beata Kowalski established that at the time of the email, she was not demanding that her daughter be returned to her to take her home. Child's condition and the medical history obtained by the hospital was established in the defense case, although these matters were not an affirmative defense. They're saying that at the end of the case, it was entitled to a directed verdict because even assuming that the Kowalskis were demanding to take their daughter home at that time, Maya was in no condition to leave the hospital, and the Kowalskis had no arrangements to transfer her to another facility. Okay, I'm coming to you guys on this. What say you about whether she was in any condition to leave the hospital? Was she in any condition to leave the hospital? Bye, Team Brittany. Bye. Were they just keeping her in the PICU because they had nowhere else to put her? Was it necessary for her to actually be in the PICU during that time? Gamer Ducko, they said multiple times she was ready for discharge. So yeah, she was ready to go. And it didn't have to be to another hospital. They wanted to discharge her with a psychiatric diagnosis that would have followed her around the rest of her life. Valor Warrior, I believe immunity needs to be taken away from any and all third-party personnel in a hospital like the position that Dr. Sally Smith was in. These laws need to be corrected. We're fighting for change. That's what we're doing here. Trying to shine a light on all of these things that need to be revamped, reworked, rejiggered. It's ironic. If they do a deep dive on Shapiro's social media, what will they find? He's thrown his wife off at the bus stop. We talked about that last night. The plaintiff did bring in all his wife's posts. Thank you, Anna. Dr. Anna, any patient can leave a hospital at any time. Yeah, and they were told that they couldn't. So I think that's the argument there. I agree. Sassy Living, they didn't prove that she wasn't able to leave due to medical, so I think she could leave. I mean, that's the testimony that I remember too. I mean, she came in complaining of stomach pain. They never found any reason for it, so Anna says, Dr. Anna, even if they have medical needs, they only have to verify they have proper transportation. Right, and if you have someone to drive you home, isn't that proper transportation? Nancy, I don't think she was in imminent danger of dying in a lot of pain. They could have tried to manage at home. They did it before. Right. Tracy, even if she wasn't ready for discharge, J. Hatch could have changed the wording of the transfer orders so Maya could leave them, continue with hospital care, and parents would be happy too. Yeah. I mean, I think we can all think of some alternatives to what they did. So that's my argument, and that's your argument too. So we're on the same page here. They are saying that at the end of the case, it was entitled to directed. All right, there are no arrangements to transfer her to another. Plaintiff did not establish that the defendant's decision to decline her release to allow her to go home was either unreasonable or unwarranted given the condition of Maya Kowalski at the time, as well as the mindset of her mother. Where's the evidence for that? It would have been unreasonable and unwarranted to send a child home under those conditions. What conditions? Because you think that her mother might be treating her with K, which is something that you disagree with, but had been prescribed by her actual treating physicians? While not raised with the jury due to its complexity, the defendant also had immunity under Chapter 39 for at least 24 hours of this period and should have immunity for this claim from the point it made the hotline call. I disagree. Thus, under the standard of care for a directed verdict, the defendant was entitled to a directed verdict once all the evidence had been presented. There was no question of fact to present to a jury on whether keeping this child in the emergency room or in the PICU was unreasonable or unwarranted when the parents had no plan except to take her home where her mother could have infused her with anything. Going to the chat on this one. Her mother could have infused her with anything. So wait, okay, so you're saying now that you didn't release her because her mother was a nurse. Because her mother was an infusion nurse, that's why you didn't release her, because her mother could have infused her with anything. Rainbow Rising, they're getting on my nerves. Just pay the money to just settle the case. I think we're all getting a lot of anxiety and agita over this. Just settle the damn case. All of you. Choosy heretics choose Carnation Revolution now. Short and long-term goals and discharge plan is all part of the SOAP note, which was intrinsic to coming up with the conclusion that we need military tribunals. How many more excuses are going to have on all of them. One step beyond you. Above an infused tea with lemon, I'm sure that violates the JH policy. Okay, even if the defendant is not entitled to a renewed directed verdict, the jury's verdict is clearly excessive because they were deceived as to the force and credibility of the evidence or was influenced by improper matters. Plaintiffs argued that the doctors did this because Beata was strong-willed and the doctors wanted to harm or spite her by keeping her daughter. This conspiracy theory is simply a fantasy unsupported by any rational evidence. This court, in reviewing for manifest weight, is allowed to consider the credibility of the witnesses and the strength of the evidence. The sheer speculation by the plaintiff that the doctors hatched a plan to imprison Maya Kowalski, when the truth is that her treating physician sent her to the hospital for emergency treatment, is not worthy of this court's acceptance, even though it appears to have misled the jury. Beata Kowalski's own email is proof positive that the facts claimed at trial do not accurately represent the events during that period, or the false claim that she wanted to take the child out of the hospital after the report was made to DCF. This court, of course, has held the defendant has immunity for making that call. Okay, they're saying that this is why this verdict for the false imprisonment claim is excessive. Without waiving all the other motions that we just made, Judge. If these motions are denied, the defendant makes this motion instead. Insert this one here. For this false imprisonment, quotes, in a hospital emergency room, an intensive care unit where she stayed for about 6 days of medical care, not 6 days of torture, 6 days of medical care, before being transferred to the 7th floor, the jury awarded Maya Kowalski $2.496 million for medical care and psychological expenses in the future. Had this claim been tried separately, it is inconceivable that a jury would have returned this verdict. There is no evidence in the court record that this event, a stay in a hospital room for 6 days before a legal stay for several months, required medical treatment or psychological treatment even in the past. Yet, Mr. Kowalski was awarded $67,200 in past medical treatment for the care of injuries caused by this event. And I just want to stop here because I want to see what you think about this. And do these numbers have any basis? And these are tangible numbers. Did Jack Kowalski sustain $67,200 in past medical expenses for those 6 days that Maya was in the hospital? These are the things that may be overturned, including the claim where the plaintiff asked for $1 and the jury gave him a lot more than that. Yeah, Sarah, you could think they are fair, but they have to be tangible. There has to be evidence that there was $67,200 in past medical expenses for that 6-day treatment. And I don't see it in the record. There are some things you can't put a price tag on, but there are some things you can. This is medical expenses. This is a tangible thing. So, yeah, the jury had 8.5 weeks to try the facts of the case and less than 2 days to determine damages. I believe it's the only valid point, right? And I'm going to say that too, that I think that the awards that were made for past medical expenses and maybe future medical expenses are things that could be reduced because those are numbers that need to be tangible. And I thought we didn't get any evidence of Jack getting any past PTSD treatment. Yeah. Okay. So, in my humble legal opinion, $67,200 for past medical expenses that may or may not exist. They're not in the record. There's no billing. There's no indication that he paid that. There are some exemplar bills that Aetna may have paid that. That is something that may be questioned by the court and may be looked at. 2.496 for medical care and psychological expense in the future. Let's see what they say about that for Maya. Neither Mr. Whitney nor Mr. Anderson suggested specific amounts of non-economic damages from Maya for this event. Instead, they suggested that the huge aggregate amount be divided up arbitrarily. They knew that the jury instructions and the verdict form required separate amounts appropriate for each claim and that this court had not included a caution that non-economic damages should not be duplicated as a result of this instruction. But they ignored the law and presented their huge ball of damages to the jury. But in addition to these awards, the jury awarded $3 million in non-economic damages for this event, for an event that did not involve any of the usual facts of false imprisonment. She was not locked in a dark closet. She was cared for in an intensive care unit. This is only the first of many awards of pain and suffering by this jury that exceed the bounds of any reasonable range in which the jury could possibly operate. Even a verdict of 10% of this amount, they say, $300,000 would be excessive. Under the law that's discussed earlier, there's not a verdict that can be used to gauge this. It requires a new trial. But if you don't want to give us a new trial, the evidence is so limited as to the damages that it's actually hard to apply the factors in the statute. The award is indicative of prejudice and passion. The jury was misled by the closing argument and ignored the evidence. The award was based on speculation and conjecture brought on by the huge lump sum recommended by plaintiff's counsel. The award bears no relationship to the amount of damages proved or the injury sustained, and the award could not be adduced in a logical manner by a reasonable person. Then they say that in order to show future medical expenses, the plaintiff has the burden to show, first, the past medical expenses. Under the case that they're citing here, Albertsons, the plaintiff has the burden to prove the reasonableness and necessity of past medical expenses. They usually do this by having the plaintiff testify about past medical bills, which is what happened in the Albertsons case, or through expert testimony regarding the reasonableness of the past expenses. The medical bills by themselves are not enough. Future damages are recoverable only when the plaintiff establishes them with reasonable certainty. The plaintiff must present evidence from which the jury can determine which future treatments are reasonably certain to be incurred and to determine the amount of those expenses with reasonable certainty. For this claim, there was no such evidence presented to support an award for $2.496 million. This is true for claims throughout this post-trial motion. As explained earlier, defendant submits that this verdict is not even a reliable measure from which to conduct any legal analysis of remittitor. But if stripped of its statutory immunity and faced only with the option of a multi-million-dollar judgment, defendant submits that the maximum lawful range for future economic damages for these few days of hospitalization would be a few $1,000s, perhaps $6,000. I think there's a number between $6,000 and $2.496 million that perhaps might work. These non-economic damages are for an event that was a hospitalization sought by her own treating physician. Okay, so now they're blaming Dr. Hannah. It's an event she does not even remember well. Thus, this event might somehow be worth a few $1,000s, but there's really no evidence to support damages to Mr. Kowalski for this event. All right. Coming to the chat. Coming to the chat. Sassy Living. Why didn't defense call someone about her medical bills during their time in trial? Because it's the plaintiff's burden. The plaintiff has the burden of proving their damages, not the defense. Yeah, $6,000 is insane. Emmy. LH, I was watching and I wasn't clear how would be another phase for punitive when there was questions for punitive in the first form. I think they could have had the same doubt and included the punitives in the first form. I know. I don't think that they knew that they were going to have listen to more evidence to come to a separate verdict on that. But they came up with more money, so maybe they weren't confused. Hi Karma. They charged $500K for CRPS treatment, but also claimed she doesn't have it. They gave her a handful of OT and PT treatments, literally like 3 or 5, over a 3-month period, and again charged $500K for that. Right? You're correct. But he didn't pay that. The insurance company paid it. So that's where it gets a little wonky with regard to awarding him that money. You follow me? Tab, I don't think they cared, says Georgina. They had been on a roll doing this for years and getting away with it all. They're still doing it. They still don't get it. Yep. Yep. It's ironic. They threatened Jack. He was afraid to challenge them because he was scared they would restrict his visitation. Yes. And that's why he also was fighting with Beata. That is correct. Sharon says she had CRPS previously. I do not know why Johns Hopkins is responsible for future treatment. And that is a question that I think a lot of people have. And I ask this of you in the chat, my CRPS warriors, because here's where I think there's a little bit of perhaps a disconnect. Can it be shown that because of this 3-month stay in the hospital, regardless of what happened to her there, regardless of the fact that she was weaned off of all of her medications and she was not allowed to have K treatments, can it be shown that she is in a worse position now, that her CRPS is worse now than it would have been had she not spent those 3 months in the hospital? What did they prove that? And if they did prove that, how did they prove that? opening it up. I am opening it up. Okay. Amber says, if untreated relapses are worse. Okay, so the fact that she was not treated for that 3 months would make it worse for her lifetime. Did somebody testify to that? Because of PTSD, Nancy says, may not be able to hold a regular job with benefits. Correct. I'm saying, but specific to the CRPS, Sam, because she had CRPS and a mother to help her cope with it. Now she just has CRPS. Correct. Yeah. But when we look at this from a legal standpoint, we have to look at every single claim individually. So that goes to the intentional infliction of emotional distress that caused Beata to unalive herself. We can't, and what they're saying is you can't lump everything in together. You have to look at each individual claim separately, and the award of damages has to be for that specific claim. Do you follow me? Let's go to not receiving proper treatment and or stress worsens CRPS. Yes. Georgina Maya's messed up big time because of them. PTSD, all of it. They deserve to pay it all and then some. Sassy Living, can PTSD bring on a flare-up? And if so, then yes, that is one reason it could have been their fault. Barry Best RN, K may have put her into remission permanently and they stopped it, so they are liable for future CRPS treatment. Well, it may have, but they're going to say that Dr. Hannah, I think, had only treated one other pediatric patient with K treatments for CRPS, right? I don't know. I'm just trying to figure out what they're trying to say here. Angela says they proved PTSD without a doubt, and stress is the worst thing for CRPS. Ray says, I think it's worse. And because there's no way to value how much worse, that's on the defense. You take your victim as you find them. Right. We call that the eggshell plaintiff rule. Very good, Ray. The eggshell plaintiff rule. So if you hit somebody in the rear in your car, and the person who's driving that other car, even though you may not hit the car really hard, or that car may not even have a dent in it, if they have a pre-existing heart condition and they die of a heart attack, that's on you. The thin-skulled plaintiff rule or the eggshell plaintiff rule. Kirkpatrick has treated 3,000 patients with CRPS. Pediatric patients? Pediatric patients? Hello, Susan Shaver. I think the plaintiff showed that she was making progress before her stay, but her stay pushed her back to a worse state. Hi, Jules. Is it the famous Jules? The famous Jules. I was in court and is in all the motions. Oh my God, I'm sorry that happened to you. Although now you're infamous. Did your TikTok blow up because of this? She ended up in the hospital with a flare-up of CRPS in 2020 because of stress. Okay. All right. Good. You guys are, and listen, you guys are the jury pool. So if you guys can all see this connection, then the argument is a reasonable jury could absolutely 100% have come to this conclusion, right? What Susan wrote. What Susan write? Susan? Oh, exactly what I just highlighted. Thanks, Scott. Thanks, Scott. All right, we come back. Okay, and then they're saying that they were not entitled to punitive damages on this claim of false imprisonment because the evidence did not support a punitive damages award, because they have to show evidence that any of them, meaning employees of the hospital, had actual knowledge of the wrongfulness of the conduct and the high probability that injury or damage to Maya would result, and despite that knowledge, intentionally pursued that course of conduct resulting in injury or damage to Maya. By falsely imprisoning her in these rooms, they say. Keep in mind that there is no claim for punitive damages from medical negligence. If the jury believed that these doctors actually breached the standard of care by taking her off of ketamine K at the massive doses she was receiving, when the doctor who had been doing this highly unorthodox treatment sent her to the hospital because it had failed, that is not a claim for false imprisonment. Where is the clear and convincing evidence that any of them were so reckless or wanting in care that it constituted a conscious disregard or indifference to the life, safety, or rights of Maya Kowalski? They kept a child in the hospital when she needed hospital care, as sought by her treating physicians when her mother wanted to take her home. That was indifference to her life and safety by clear and convincing evidence? If evidence sufficient to present this first issue to the jury exists, where is the evidence that a true managing agent committed this? Okay, so if we did do that, and if that evidence is good enough, where's the evidence that it was one of our people and not Sally Smith? I say, who made that second DCF call? That's the person that I'm going to blame. So I think that there is a reasonable basis for the jury verdict on this cause of action. What say you? They're saying there's no evidence that an officer or director of this nonprofit corporation was involved in this event. So they should have a directed verdict. And if they don't have a directed verdict, then they say that the punitive damages award of $15 million is more than a jury would typically award in a tobacco case where the plaintiff dies a slow, painful death. I would argue sometimes it is more painful to live than to die. Under the leadership of juror number 1 and the arguments of plaintiff's counsel, must have been overwhelmed by improper passion and prejudice, because there's no way that they could come up with a $15 million punitive damages award. And I say, yes, they could. Then they talk about the court unpleading the specific intent claim in the second phase of the trial, and then to emphasize it by placing it twice on the verdict form with alternative burdens of proof. There was no evidence that any of these board-certified pediatricians in a children's hospital had an intent to harm this little child, much less a specific intent, i.e. an intentional tort performed for the specific purpose of harming the child. If what they're saying is true, and this is the standard, can somebody in the chat, and I know you can, show me or tell me what you think was the specific intent that is required for this claim? Who did it, and what was the specific thing that they did with intent to cause harm to Maya? Hello, patrons galore. Gothic Brina. Look at the text between the staff members. Yes, but Maya didn't know about those until trial. So let's think of something that they actually did to Maya while she was there that Maya was aware of that shows intent. Yes, Sarah, that is a different cause of action that we're going to come to in a sec. Hospital by not treating her for a previous diagnosis. And I think that could be the intent. And they were intent on doing that, weren't they? Because they didn't want to believe it. They didn't want to believe that Maya had CRPS. Rochella held Maya hostage in a hospital and not seeing her family. Jules, they intended to put her in a room for 48 hours to prove she was faking. Yep, that's the next one that we're coming to. That is 100%. They definitely intended to do that. And therefore, in my opinion, a reasonable jury could absolutely have come to this same conclusion. And for all of those reasons, Judge, we think that you should throw it out because absolutely improper passion and prejudice. They can't show specific intent. I'm going to disagree and say that I think they can. They're saying, but even if you do think so, Judge, we're going to ask you to reduce this huge award of punitive damages from $15 million to I don't even want to say this out loud because you guys are going to go berserk. $15 million to $18,000. $18,000. Good luck with that. Okay, now they're talking about the claim for false imprisonment for the October 18th to 20th, which is when she was in the EEG room. They say this claim, because these are all separate claims. Remember, they got to award a separate amount for each one of these claims. The first claim was for the 6 days before the shelter order was in place, when they intentionally, in my opinion, did not let them leave by telling them they were going to be arrested or something, or security was going to stop them on the way out by intentionally lying to them. They did intentionally lie to them by telling them they were not allowed to leave, when under the patient bill of rights that we saw in evidence, they absolutely were allowed to leave. There's no requirement that you have to leave to be transferred to another facility. People leave AMA all the time. Somebody said in here, I forget who they said, somebody was shot 5 times and like checked themselves out the next day. You can. And at that point, they still had their parental rights. It was their decision whether or not they could take their child out of the hospital, not the hospital's decision. Just because they were imminently waiting, they thought that this decision would be coming any second. So they kept delaying and delaying and lying to them and lying to them. There's where I think the intent is, in the lying by telling them they were not allowed to leave. So now they're going to talk about the EEG room. This claim involves the decision to move Maya Kowalski down the hall from her room on the 7th floor, where she was currently staying, to another room that had video capabilities. That room had the capability to allow for EEG testing, which played no role in this case. Again, lies. When in this room, Maya was video recorded without her knowledge. Oh, so they're admitting it now. See, a lot of these admissions are going to come into play too. Hey, Tiny Tina. What baffles me is that they're trying to take credit for how Maya what? How Maya improved? So are they implying they're responsible for Piata's? Oh no, they're absolutely going to say that they are not responsible for Piata's. Boom. Yeah, that's it. There's the smoking gun, Jules. When in this room, Maya was video recorded without her knowledge. Admission. This was done as a test to see if she would engage in activities that were consistent or inconsistent with CRPS when she was not aware that anyone was observing her. This decision was made by Dr. Paula Dees. Dr. Sally Smith also wanted this testing done for the DCF proceeding, although it ultimately played no role in that proceeding. Yeah, because you didn't find anything. You couldn't prove that she was a liar. Couldn't prove that her mother was inflicting this upon her. So why did this go on for so long? Because Sally Smith didn't think it was important to put any conflicting evidence in her reports that she was likely paid very, very well to render. Not my job to put the other medical records in there. That's their attorney's job. I submit to you that they never should have even had to hire an attorney. This makes me mad. All right, let's take a breath. All right. This is a long one, you guys. I'm sorry. I know it's long. You're probably getting bored listening to me, but you said you like my voice, so AMSR, ASMR, whatever it is. The process was not actually treatment of Maya Kowalski. Well, there you go. Now they're admitting that it was not actually treatment of Maya Kowalski. But P.S., we billed for treatment, but now we're saying it's not really treatment. This admission could hurt them if there's a third party proceeding against Aetna who paid the medical bills. I think it's Aetna. It was primarily a non-invasive diagnostic test. If Maya engaged in actions completely inconsistent with CRPS, then that diagnosis could be rejected or at least highly questioned. If she did not, then CRPS would still be a possible diagnosis. Oh, so at what point did you decide that since she didn't do any of the sneaky things you thought she was going to do, that she actually might have CRPS? The evidence is all over the place with regard to that. And every single one of those militant hospital witnesses, mostly women, which was surprising to me how militant they were about a child being a faker. So now you're saying that after October 20th, you should have still been considering CRPS because you didn't treat her at all for CRPS. The doctors did not obtain, and here's another admission, the doctors did not obtain a separate and specific consent of the parents to move their child to this room for this test, although a consent to photograph was obtained at admission. In retrospect, at least Mr. Kowalski could have been informed of this test if he made sure that no one told Maya. But this was still not a treatment or an invasive test of the sort for which consent to perform the procedure often requires consent. Okay, so we didn't. We did it, but it wasn't treatment. It was a diagnostic test. But it wasn't a diagnostic test because it wasn't invasive. And even if it was a diagnostic test, it's not the kind of diagnostic test that we would require consent for, that any hospital would require consent for. Because it's not one of those kind of tests that would require consent. We can pretty much do whatever we want because when you bring your child to the hospital, and I have 5 kids, so if any of you have ever brought any of your children to the hospital, you know that when you go in there, you are so worried about your child, they hand you a stack of papers to sign, and you just sign them and throw them back. Does anybody ever read what they're signing? Number 1. And number 2, are you saying that there's some blanket, there's a consent to photograph buried in these papers, which I think we did look at, that nobody would have even seen. So it's okay that we took the pictures of her, but we really didn't get consent for this test. But even if we did this test, we didn't need to get consent for it because it wasn't really treatment. It was just a trick. It's like a little magic trick that we were doing just to see. It was like a little trick. And then this is where the words get a little crazy. But this child was rolled down the hall to this room just as she had been moved occasionally to other rooms. She claimed at trial that she was imprisoned, but in the video recording, she shows no signs of thinking she was imprisoned. This child probably wanted to go home every day she was in the hospital, but that was a decision for the dependency court, not this defendant. Not this defendant who set these wheels in motion with the second call to DCF. This is where they're screwed, in my opinion. That second call. It's the second call that's gonna, just like Alec Murdoch was screwed over by Snapchat. That was his demise. That Snapchat video was his demise, right? They're gonna, and this isn't a criminal case, so it's not a great analogy, but it's the second DCF call to me that sunk him. The jury clearly did not review the video that is in evidence. Defendant files a brief index of locations on that videotape that show the child doing the normal things she did in any other room, leaving the room, sleeping, doing crafts, etc. The activities on this video are a little different than her activities on any other day in the hospital. Except for she didn't have her mother. Yes. Thank you, cat lady. That's exactly what I was going to say. Since when does a video show a person's thoughts? How do you know what she was thinking? She probably wanted to go home every day she was in the hospital. Yep. Thank you, American Nana. Amazing what was not in her records. Yep. 6 hours. She was on the floor for 6 hours. I didn't see that. Wow. Sarah, why are they having patients sign consent to treat you when you are drugged? Well, I think that's a separate question for adults because Maya didn't sign any consents. She doesn't have the legal ability to sign any consents. It would have been Jack who signed them when she came into the ER. Jules, you had a good question. I'm trying to get here. Trying to get you here. I'm trying to get to it. Let me go back because the chat was moving real quickly. Okay. Now that you're seeing these admissions, where does it go from here, please? Will these admissions hurt their appeal? If they contest those things that they've admitted, yeah. But I think that these admissions are definitely going to work against them. If any of these admissions, if they're going to deny them later and say, oh, our attorney said that, but it wasn't really us saying that. They're not going to be able to contest any of these issues that they are now admitting to. Does that make sense? Because they're swearing to this under oath. I mean, this is an attorney's pleading. Sam, so they left this little girl in terrible pain, isolated her from family and anyone who looked out for her, held her down and took bra photos, but they didn't hurt her because she looks okay. Yeah, and because her thoughts, she probably was thinking this or that. And you can clearly see that because she was doing crafts. Very best RN. It was an orchestrated plan to make money on the backs of the Kowalskis and the insurance company. I hope Aetna asks back for the money they paid for this hospitalization. Not to mention, Cat Lady says, Tepa Sanchez said Beata said she was fine as long as she had her family, so she reports to her to DCF to take away her family. Yep. LH, this is the self-snitching motion. Do you guys watch Bruce Rivers, Criminal Lawyer? Oh my God, I love him. He's so funny. He talks about self-snitching all the time, and he'll just do like a whole 20-minute video of some criminal self-snitching, and that's his whole catchphrase, like, stop self-snitching. And it's funny. CBS owns Aetna. You can listen all night, Spirit Healing, really? Yeah, do you guys watch Criminal Lawyer Bruce Rivers? Tell me. He's so funny. I think it's like CLR. Bruce Rivers was the first lawyer on YouTube I watched. Me too. Me too. And I don't even know how he popped up in my feed, but I thought he was so funny. Bruce Rivers, I'm the criminal lawyer. He has a whole song, and his son is the one who convinced him to go on YouTube. And he's an older guy like me. He's a criminal lawyer, and he's been doing this for a long time. And I think he's in I think CLR. Is that the name of his channel? Criminal Lawyer Rivers, maybe? I don't know. And his son convinced him to make this YouTube channel, and he's got millions of subscribers. He's got a lot of subscribers, and he just makes these self-snitching videos where he finds video of like criminals who are confessing to things that they should not be. I've learned a lot actually from watching his videos about what to do if, God forbid, you're ever arrested for a crime. No, I never heard of him. Well, go find him later. Don't go now. Don't go now because I want you to stay with me. But totally, Kirsten, you love him too. Yes, he's very, very funny. He does over 1 million subs, right? Maybe even 2 million by now. Armand, I don't know. He's a sassy lawyer. He is. He's very funny. He's very funny. And I don't curse on this channel, but somehow his cursing doesn't really bother me because he's just, I love CLR. Yep, everybody loves him. Bruce Rivers. All right, Bruce Rivers, if you get a whole bunch of new subscribers after this, come talk to me. Maybe we can collaborate on something because it would be funny. Says Christine. Oh, Sarah, content genius. Yeah, I think his son is behind that whole channel, right? Because his son, I think, also runs camera for him. And his son may even find these videos for him to comment on. And it's like, criminal lawyer reacts. Maybe that's why it's CLR. Duh. Yeah. Okay. Gotcha. Criminal lawyer. Oh, Ray, look at you coming in with the intel. Thank you. Thank you, mujer barroca. And his pearl-handled revolver cufflinks. Yeah, he's very funny. He's a comedian, so it's like funny LawTube videos, but they're short and funny and very funny. All right. I'm NAL, not a lawyer? Oh, look at that. I'm learning some new verbiage and abbreviations. Like TBH. We all know about TBH, right? But from what I observed in court, I think Judge Carroll is going to take 5 minutes to deep breathe and deny these motions. I may be wrong, though. Yes, I think that you are correct. And what I think we discussed before you came in today is that Florida laws of procedure, the rules of civil procedure in Florida require that the defense make this motion to the trial judge first, and that it is up to the trial judge to either grant or deny them, because they say that he is best equipped. Judge Carroll is the best equipped judge to decide these motions because he, like the jurors, sat through all the evidence in this case. Therefore, they must go to Judge Carroll first. Judge Carroll will probably not want to overrule himself, right? Or admit that he did anything improper, because he believes that the decisions he made during this trial were the right ones under the law. And that is judicial discretion. And then, after Judge Carroll denies some or all of this motion, they will appeal that, and then they can go to the appellate court. So that is just the procedural rules that need to be followed in this case. And we'll see. I mean, there's an appearance on, is it December 15th on this case? Because I'm working on about 5 cases at the same time. Let me just look. I have the court record open. December 15th. I don't think they're going to hear them before then, but Jules, if you have other information and they moved it up, let me know what you think. How can Judge Carroll grant a new trial when they admit in these filings of their wrongdoings? You don't get a second bite of the apple. No. Well, you can in a civil case if there are things that could cause a mistrial or a new trial or a directed verdict. You can. You cannot in a criminal case. In a criminal case, there's something called double jeopardy. So if you are tried and a jury finds you not guilty, you can never be tried for that case again, or that claim or that crime. But they're admitting certain things, but not admitting other things. And that's where it gets a little sticky. Right. I knew I was a nerd when my friend asked me my celebrity crush was, and I said Bruce Rivers. People think I'm crazy when I say Will Ferrell. Like, what? Like, if you could have a hall pass, you're picking Will Ferrell? Well, I don't know. I like Will Ferrell. December 15th, 8:30, right? And it's a different courthouse, right? It's not going to be in Venice. It's going to be in a different courthouse, as far as I know. Thanks, Jules. Thanks, Jules. Everyone appreciates you being here. Welcome. I don't think you've ever been here before, but thanks for coming. Yeah, Ray. Judge Carroll's demonstrated to me I can never be a judge. He treated them like how people treat their kids. Yeah, it's very, being a judge is a really hard job. And you see how he was so patient. And when he needed a moment, he would say, I'm going to leave for 5 minutes. And he would take a breath and he would leave. He'd walk out. I mean, I have, in over 30 years of practice, I have dealt with some really, really mean judges. And, back in the 90s, when I was a young woman lawyer, there were not a lot of women lawyers, especially out here in Suffolk County, New York. It was the old boys club. And in many ways, it still is the old boys club. And there were some really mean judges. And there was a judge in Brooklyn who would not allow women lawyers to wear anything but skirts into court. If you came in slacks, he would send you home. And if you didn't take your coat off and walk up to address him, if you walked up to address him with your coat on, you'd get sent home too. That was a judge in Nassau County, actually. So being a judge is a very, very hard job. And, quite honestly, they make a lot less than the lawyers do. So, I don't know if it's worth it. It's very political too. Well, thank you, Rachella. Please take a second and hit the like button. Thank you so much. We've managed to keep everybody that's been in here for almost 3 hours. So, let's keep going. They're saying the jury did not look at the videotape and therefore Suffolk County, that's correct. That is where I practice and where I've been practicing and where I live. I live on Long Island and I've been handling all the serial killer information as well because that's a very personal case to me. Because we've been dealing with this serial killer since 1996, and I also did some deep dives, yeah, I guess deep dives into some cold cases on Long Island from the 1980s that we all think could possibly also be related to the Long Island serial killer. But I digress. Okay, let's get back to this motion because this is going to be a lot of the same thing. But now they're saying that they should definitely get a directed verdict and a new trial because of the videotape and it's conclusive evidence that she was not falsely imprisoned or that she even thought she was falsely imprisoned. Therefore, we should get a directed verdict and a new trial on that, as well as this is not a claim for invasion of privacy. Using videotape to help in diagnosis is not false imprisonment at all. Could have been done in her previous room if it had a camera. This is not a claim for invasion of privacy by use of the video equipment. The recording was given to the parent's attorney within a month and not ever shown publicly by the defendant. Only the plaintiff publicized parts of this video to the public. They're really patting themselves on the back for not publishing the videos of her in her shorts and sports bra or publishing the videotapes of her. And they're really, I mean, they feel like they should be commended for that, which is a little weird to me, but what say you? This court has ruled that the defendant had no immunity for performing this test, which had relevance to the DCF proceedings as well as to her diagnosis. But immunity aside, there was no disputed question of fact to present to a jury to whether moving this child to another room on the 7th floor for 2 days constituted false imprisonment. Even if we're not entitled to a directed verdict, we are the jury's verdict is clearly against the weight of the evidence. And no imprisonment occurred because despite her testimony after many years of replaying events in her mind, the video shows no evidence that Maya Kowalski thought she was any more imprisoned in this room than the room she was in the day or two before. You can't tell that from a video. Am I wrong? How can you tell what she thought from a video? That is just a stupid, stupid argument. He might have some good arguments in here, but that's a stupid one. And I haven't seen the good ones yet, but I'll let you know when we get to them. Admittedly, the entire hospitalization on the 7th floor may have been against her will. Okay, so we're admitting to that. Okay, good, good, good. But the dependency court and not this defendant is responsible for that. Oh, okay, so it may have been against her will, but it wasn't our fault. It was their fault. The jury simply could not sort out the acts for which the defendant was possibly responsible from those for which it had total immunity. Well, if they couldn't sort it out, then you didn't do your job, Hunter. You didn't do your job. Maybe you should have explained it a little bit better. Maybe, Mr. Shapiro, in your closing argument on punitive damages, you should not have said something like, I need the full screen for this so you can get the full fact. Don't blame us because you hate Kathy Beatty. Don't punish us for Kathy Beatty because she doesn't even work here anymore. If you award a larger amount of money, this is going to send a chilling effect to all of the children with cancer and also mandatory reporters. Don't do that, jury. You know what would have been a lot better, in my opinion, for that argument? Ladies and gentlemen, we are really sorry about what happened to Maya Kowalski. We are really sorry. We wish that none of this happened to Maya Kowalski. But we can't turn back the clock. We did the best we could with the information that we had at the time. And we didn't mean her any harm. And we didn't mean her any ill will. And, something like that. Thanks, Ed. Very nice dramatic read. Thank you. Thanks, Sarah. You'd hire me for Law and Order SVU. Could you get a moonlighting job as, the casting director for that office? They're back. They're back on set now. I saw Mariska Hargitay posting some pictures of her and Elliot Stabler. I think they're back on set. That's pretty exciting. Hopefully my phone will blow up with all kinds of audition requests, and I'm gonna hang out there for a day or two. The Gilded Age is filmed right here on Long Island. Does anybody watch The Gilded Age? I know I'm going off topic for a second, but I feel like we just need to take a deep breath. The Gilded Age. Anybody watch The Gilded Age? Love it. The costumes, the set design, bus stop people unite. Thank you, Lynette. Thank you. I have auditioned for Law and Order SVU, Law and Order Regular, and Law and Order not Criminal Intent. What's the new one? Organized Crime. A lot of times to play a lawyer and to play other things like the rich mom of the college student who commits crimes. But so far, I haven't booked it. And then the strike happened, and COVID, and then the strike. So it's been a lot of years of deciding to just come on here and create YouTube content for people who wanted to listen to me for some reason. I still can't figure out, but I'm enjoying you. So I thought this was the Gilded Age. Yeah, it's supposed to be, right? The Roaring 20s. We're supposed to be having the Roaring 20s right now. Oh, New Hampshire woman, you love the Gilded Age. I do too. Maybe one night we could do a podcast about shows that we're watching and just talk about what we think's going to happen. What else am I watching right now? Killing Eve. I'm on season 3. I never watched it when it first came out, but it's pretty good. I think they're kind of losing me in season 3. Okay. All right. I don't want to admit this, but is anybody watching The Golden Bachelor? Is anybody watching The Golden Bachelor? When is the finale? Oh, thank you, Arlene. I'm gifted. My teachers did not feel that way about me. My mother has saved every piece of paper from my entire life. Sometimes she tries to pawn off on me bags and bags of things like my report cards from elementary school. And they're like, Melanie does not work to her potential. But thank you. Thank you for telling me I'm gifted. You guys want to take a bus trip to Sarasota? Oh, Sarasota. I'm thinking of Saratoga Springs. I'm like, that's not that far. I'm like, Sarasota, Florida. I can't get on a bus for that long. My back wouldn't be able to take it. Thank you, Sam. Killing Eve was great until season 3. Yeah, they're kind of losing me now. Like the season 2 finale was like, all right, great. This is going to be great. And then, yeah, Jury Duty, the TV show. Thank you. That is hilarious. Whoever has not watched that on Amazon Prime. Oh, I just got an alert that Chad Daybell wants his murder trial televised. Okay, good. We'll be covering that. Do you guys want to see the Chad Daybell trial? Because I know I do. Golden Bachelor. Anyone? Is anybody in here watching the Golden Bachelor? It's giving me hope anyway. It's giving me some hope. All of the women, the Bachelor himself is like 75 or something. All of the women are like 65 plus, and they are in their prime. I mean, it's great. And they're nicer to each other than some of those Bachelor contestants when they're younger. Who's from Florida? The Bachelor? The Golden Bachelor? Are you watching it too? Gary. I don't like they call first of all, they call him Gary, right? They call him Gary, but they spell it Gerry, which in New York we call Jerry, and it's usually short for the Italian version of Gennaro, right? You call him Jerry with a G. So why do they call him Gary? But it's Gerry. I don't know. That annoys me, but they didn't ask me. Oh, yes, Clarabella, I will. I'll do a video about the Catholic Church cases that I fought for. That was 15 years of my life that I'm never getting back. That really didn't end in the way that I wanted it to. But, New York was the most pedophile-friendly state in the country. If you keep a kid quiet long enough, you'd never go to jail and you could never be prosecuted civilly or criminally. Oh, you got the same report card, Moonlight View, about not working up to your potential? Being too distracted, not doing all your homework. Yes to Daybell. All right, and we have Barroca. Yes to Daybell. Yes, Lynette. Yes. Hey, Jason, what up? Want to see that trial? No to the show. All right. Nobody's watching The Golden Bachelor except for me. It's not filmed in the Villages, but I want to just say something. Do you know that the Villages has the highest STD rate in the country? Did anybody know that? Does anybody know what the Villages is? Like, that's all I'm gonna say. I'm gonna leave right there. Yes, Jules, that was me. At least in the New York cases, the Long Island cases. The movie Spotlight, that's the real life stuff that I was involved in. The scandal started in Boston, but then Suffolk County, it's the only good thing they ever did was issue a scathing grand jury report against the diocese out here for shuffling the priests around, not telling the parishioners, and all kinds of fraudulent things. But the jury, the grand jury did not allow any criminal charges to be brought. So you just spit your drink at the Sarah. If I could make you spit out a drink tonight, then I feel like I could just pack it up right now and find something to eat for dinner. Jules knew that. Jules knew that. Sam's like, yep, I know the Villages. Ew. The Villages in Florida Midnight Muses of Republican STD Utopia. Yep, excellent student, but talk too much, LH. I had that too. It needs to improve self-control. What in the world? How are you, run the world? It's all that Viagra, NH woman. Yeah, and all those women who know that they can't get pregnant. So it's like, whatever. Whatever. Oh my goodness. Okay. All right. We're going to go back to this. Would you like to go back to this? Because there's a lot of it left, but I think we can sort of either we can do part 2 of this tomorrow, or we can sort of, just I'll tell you what they think. All right. So we say because of this false imprisonment of 2 days, they should never have awarded her $1.4 million for medical care and psychological expenses in the future. There's no evidence in the record that this 48-hour event required medical treatment or psychological treatment even in the past. Yet he was awarded, again, Mr. Kowalski was awarded $561,298 in past medical expenses for the care of injuries caused by this event. I'm going to tell you, in my professional legal opinion, that will probably be overturned. There is no evidence in the record that I can recall. Jules, you can tell me, you were there every single day. Did Mr. Kowalski expend $561,000 for the 48 hours that she was in that EEG room? Listen, I'm all for the pain and suffering awards. I'm all for the stuff that's not, but that is something that they really need to show, and I don't think they showed it. Know what I'm saying? Know what I'm saying? You want to do part 2 tomorrow because somebody else is going live in 20 minutes? What time is it? All right, so we have 20 minutes here. We have 20 minutes. I know, Jeff, you did warn me last night that it was long, and I know, and I highlighted the whole thing and I read it over. I'm like, I can whip through this. I can whip through this. So the past medical expenses, I think, may be overturned. The future expenses, $1.4 million for specifically this 48 hours, that may be something that they may think is excessive. The $3 million in pain and suffering, again, that I think is something the jury can make that decision on. Okay. So again, they're saying for an event that did not involve the usual facts of false imprisonment, like, being beaten up and like not even being beaten up, but being like chained to the floor and in a dungeon, I think they said. And they're saying that we should get a whole trial because there's no way you can reduce that. But even if you do reduce it, here's what you should reduce it to. And we think that you should reduce it to less than $5,000 because the videotape shows that she did have nursing care and physical therapy during those 2 days and did leave the room and sleep normally as demonstrated by the videotape. And maybe you could throw in another $10,000. I think pain and suffering award is 100% within the jury's province to award at their discretion, and I do not think that that is so egregious that it could be overturned. But I do think this case should settle. I really think this case should settle. Nobody should risk any, kind of negative verdict, negative appeal, negative anything, just try and settle the case for a number in between 0 and 261 million that the plaintiff is happy with. No, yeah, I know. So what if she's not screaming, she's not impacted? Yeah, I know. I know. Yes, Dominique says, I think she got way too much, but I don't reduce to a ridiculous amount like they are going to say. All these things. Yeah. And like I was telling you before, that other case in Florida in August of 21 had $1 billion verdict for a 19-year-old who was sadly killed in a car accident with a tractor trailer. And the tractor trailer, they awarded $900 million in punitive damages because he was texting. So, this doesn't shock the conscience, and it won't shock the conscience of a Florida judge that knows about that $1 billion verdict. So here they say we should get a new trial because blah, blah, blah. We didn't do anything intentional. Again, there is no claim for punitive damages for medical negligence because of this stay in this room. It wasn't intentional. The plaintiff did not prove by any weight of the evidence that this non-invasive test was performed at a great risk of injury to the 10-year-old child or that any bodily injury resulted from the 2-day stay in this room. Where is the clear and convincing evidence that any of the members of the staff were so reckless or wanting in care that it constituted a conscious disregard of indifference to the life, safety, or rights of Maya Kowalski? The videotape demonstrates that her life, safety, and rights are a little different in this room than in the room in which she stayed before and after this test. The defendant is entitled to a directed verdict on this claim. It was also entitled to that relief on summary judgment and at the end of plaintiff's case. Yeah, I mean, you think they still don't get it? Lorraine says, I wish the judge could order no more future subpoenas on Maya's medical doctors from now on. Yeah, that's why she's not treating, right? Dominique says, but Jill says it was intentional. You admitted you did it to prove she was faking. Yes. Correct. Jules, maybe you should go to law school. Maybe you should go to law school. It's never too late to dream a new dream. Because, I became a recovering lawyer about 8 or 9 or 10, however many years ago, and decided to become a YouTuber. Decided to become a YouTuber really like in June, but I decided I wanted to be an actor. I didn't want to be a lawyer anymore because it was sucking the soul out of me. So now I'm a recovering lawyer, legal commentator, and analyst. I'm still a lawyer by trade, but it's never too old. You're never too old to dream a new dream. And we decided the other day that Lewis Carroll said that, the guy who wrote Alice in Wonderland. All right. They're saying $15 million, ridiculous. Under the leadership of juror number 1, you should reduce it. And we're going to say that, first of all, you should overturn it, give us a new trial. And if you don't want to overturn it and give us a new trial, then you should definitely reduce it, but to no more than $45,000. Then they're going to talk about taking the pictures of her on January 6th. And they're saying that the defendant continues to maintain that this event occurred because the dependency court ordered Maya to attend court on that day. The photographs were taken before she left for court to establish the condition of her skin at that time and when she returned. But this court has ruled that the defendant had no immunity for this event. Okay, they're agreeing that they have no immunity for something, finally. Immunity aside, this claim involves Maya Kowalski's testimony that she was placed in a room for a few minutes and photographed. They're going to minimize this. That's going to make you mad. Trigger warning. She was placed in a room for a few minutes and photographed in her shorts and bra prior to being released from the hospital to go to court and see Dr. Duncan and Dr. Hannah on the day of the hearing, following which Beata Kowalski wrote her notes. Plaintiff claims that she was stripped naked in this process, but no such photographs exist, and the 2 hospital employees deny that any such stripping took place. Okay, that's why they call it a question of fact for a jury, because we have conflicting testimony, so the jury gets to decide that question, so you lose. You lose. And stop trying to minimize it because you're just pissing people off. But assuming the truth of Maya Kowalski's event, the recollection of this event at almost age 18 of events when she turned 11, the event lasted a short period of time. She was on a hospital bed that in some of the pictures has images of her stuffed animals. Oh, so she must have been happy because she had stuffed animals. Oh, for crying out loud, why didn't you just open with that? Why didn't you just say, in the beginning of your opening statement. You're going to hear a lot of testimony, jurors, but just remember, Maya had her stuffed animals with her and some Shopkins sometimes. Thank you. And sit down. Thank you. Thank you. Hostronic, a few minutes can traumatize you for a lifetime. If someone is R-worded and it only lasts a few minutes, does that make it less traumatic? Thank you. Thank you for not saying the word. I appreciate you. And that's exactly the analogy that I was going to make. How long does an SA take to happen? Oh, it was only a couple minutes, so, shouldn't really affect you. And there was a stuffed animal in the room. So you should have felt some creature comforts from that. Once again, Melanie big. Once Melanie gets big, I'll stop chatting because I can't stand slow mode. Nah, I'm just a little. Look, we got 330 people watching, but you know what? It's like a party in here. This is like a party. This is like a bunch of good friends hanging out, talking about whatever we want to talk about, drinking whenever we want to drink. I have iced tea in here. The other night when I said that I was drinking Gatorade Zero, I got like 10 comments in the stream about how it causes cancer and like comments like after the video. I was like, oh, Gatorade Zero causes cancer. It's bad for you. Like I thought it was zero. I thought it was replenishing all my electrolytes. I don't know. Maybe I got to rethink my drink of choice. What apps? No, not Long Island iced tea. It's Crystal Light, actually. Crystal Light iced tea that I buy in bulk from Amazon. Yes, the hospital has deep pockets, Dominique, Rachel, and Jill says, exactly. Courtney, I had stuffed animals when I was improperly imprisoned in a hospital too, and it didn't make it better. Just made me afraid of my stuffed animals too. They really don't get it. Courtney, that's a great point. I'm so sorry for what happened to you. I'm so sorry that you were actually a victim of also being imprisoned as a hospital as a young child. And I just got the chills from that because that really just breaks my heart. And I'm really sorry that that happened to you. I hope it wasn't at this same place. A tiny Tina. I'm not going to read it, but it's funny. Oh, Midnight Muse over here. Working on artwork and chiming in, and I think some snark is needed. We've got a lot of snark tonight, and we're okay with that. We like the snark. Oh no, LH, stop. Really? My cousin was ran over by a car in front of me when I was 10. The moment lasted like 2 seconds and she survived. I'm almost 40 and I still remember it like a movie. They invalidate PTSD so nasty. I'm so sorry that happened to you when you were 10. That's heartbreaking. That's heartbreaking. I'm sorry. All right, so they're going to minimize this taking of photographs because there were stuffed animals there. She appears to be upset at this procedure. Well, they admit to that, but there's no evidence in the photographs that she was struggling or that the two people whose hands were shown were doing more than simply holding her hands. Just holding her hands for comfort, guys. There's no evidence that she was tied to the bed or okay. There's no evidence that she was tied to the bed or physically restrained by holding her head or feet or other parts of her body. There's no evidence that this photographing required more than the assistance, because that's the only way in hell that you can even award any damages for this claim. And I am not even going to give them the satisfaction of continuing to read this, because then they say the hands do not even seem to have the same complexion of Miss Beatty, and everyone's seen R.A.'s picture where he imposed her hand over that hand. And yes, Ray, she was 10 years old. That was 10 years old. Jules, we could see this on TV too. That you can confirm that when Greg said I had a flare up during trial, it was true. We could see it. We could see it on TV. We could see it every day, how it was affecting her. And there were some days that she didn't come to court and we knew why. We could see the difference in her appearance and how she looked, and how you could just tell how worn out she was and tired she looked as the days went by. And there were some days that we could see that she was better than others. And it was evident. We didn't even need to hear it from anyone. But we saw it. We saw it. We saw it in her eyes. We saw it in her face. Because you know what? 'Cause the stream that we were forced to watch until we discovered Recovery Addict was, focused on Maya's face the whole entire time of every single day that she was in court, so basically all we got to see. And then even some of the I don't think the Zoom stream was always like that, but it was pretty bad. One step beyond you. I was run over by a car when I was 17. I got up and tried to walk away, but onlookers stopped me. I think I gave them PTSD. Oh my god, you might have. Are you okay? Are you one of my CRPS warriors that was the triggering event that gave you CRPS? Okay. All right. So anyway, they're going to minimize that and they're going to say that didn't cause any distress and therefore we need a new trial. And we believe, as the defendant, that under all the circumstances, the photographs that we took of her were not unreasonable or unwarranted, and therefore you have to overturn that verdict. And we need a new trial on that if you're not going to overturn the verdict, because the Kowalskis signed the release form on admission, allowing for photographs. We all know how we feel about that release form. I say, go scratch on that. And they're saying that also, they awarded her future medical expenses for this event for less than an hour for $188,000 of medical care and psychological expenses in the future. And again, the $325,000 in past medical expenses for this, however long it was, event, I don't know that that can be shown in the evidence, and that is something that you do need evidence for. Whereas the pain and suffering awards are completely up to the jury. This is something that really needs to be proven, this $325K. I don't know that they've proven that. We can't just be pulling arbitrarily numbers out of the air. And, this may not have a basis. Okay. So that may be one thing that I agree with. Then they're saying the jury awarded Maya another $15 million in non-economic damages, meaning pain and suffering damages, and they're going to minimize again for an event that did not involve any of the usual facts of a false imprisonment where a person is locked in a room or intentionally tied up and tortured. Well, because that case would be worth, I don't know, $1 billion, not a paltry 15 million. This is the third example of an award of pain and suffering by this jury that exceeds the bounds of any reasonable range in which a jury could possibly ask for. I disagree. I don't think that's outside the range, the bounds of any reasonable jury. What do my reasonable jurors think? My cupcakes. What do you think, cupcakes? Do you think that's unreasonable? 15 million for being held down, stripped to your undergarments and photographed by a woman that you hate and that they know that you hate? I don't think so. They're saying, well, you should reduce it, but if you're not going to give us a new trial or you're not going to overturn it, 75,000 would even seem high, but that would be closer to the correct amount. The maximum that you should reduce this to, judge, is 150K. Then they're saying, but if you're gonna reduce the compensatory damages, how about 50K? Or less than 50K. Then they want, or 150. The maximum range would be 150. Again, punitive damages, they're saying, again, the question is, where is the clear and convincing evidence that any person in the room during this event or any person involved in setting up the photographic session, quote, had actual knowledge of the wrongfulness of the conduct and the high probability that injury to damage or damage to Maya would result, and despite that knowledge, intentionally pursued that course of conduct, resulting in an injury or damage to Maya Kowalski. Come on, people. You know the answer to this one. Bueller? Anyone? Bueller. They are a children's hospital. All they do is treat children. Of course, they had actual knowledge that holding a little girl down, stripping her down to her skivvies, and photographing her would, in all likelihood, cause her to have PTSD in the future. So that argument is spurious at best. Spurious. Did they say why they took photos? Hi, Noni lady. How are you this evening? Yes, they did. They said they had to take photos of her to show her condition of her CRPS lesions before she went in to court, and then took some more photos when she came back. But those photos never made it into the court. I mean, into the court record. They never made it into the medical file. Never made it into her chart. We don't even know where the camera is. We don't even know whether it was Kathy Beatty's phone that she took the pictures with. That whole part of the trial was very, mysterious. Nobody knows where the photos are. They had some photos, they didn't have some photo. Who had the camera? But I say if you are a children's hospital and you do this, you absolutely 100% have actual knowledge of the wrongfulness of the conduct and the high probability that PTSD would result. And despite that knowledge, you intentionally did that because, again, you're trying to cause that you were trying to prove that she was lying and she was causing injury to herself. Right? Where were we reckless? Well, I'm going to just even skip because I just think that's easy. They're saying here, yes, exactly your question that you just asked. The photographs were taken to document a questionable appearance of lesions on her body. And they were taken because she was required to leave the hospital on a court order. Wow. Hey, Susan. Oh, you changed your name. Yay. Susan, the camera fell in the water like the 10 cell phones. Yep. Yes. Oh, I don't know what I just did. Uh, Jill says, believe me when I say, Tiny Tina is a real trooper. She struggles with severe pain on the daily too. Oh, Tiny Tina, I think you found your people. I think you have just found your people and they are all in the chat. So many of my viewers are sadly afflicted with CRPS. Some have been suffering with CRPS for at least 50 years. So many with other chronic pain disorders that took a long time to diagnose and were medically gaslit throughout their entire medical history because doctors were telling them that it was all in their head and they were making it up. And we also are trying to raise CRPS awareness, and we have made merch, Team Maya merch, which is linked in my channel. I don't think I got the opportunity to link it to this video yet, but I will. But all the proceeds from the Team Maya merch, the t-shirts, the hats that I made are being donated to CRPS research. So Tiny Tina, I think you have found your people. We see you. And we know what you're going through. Cat Lady says, yep, fibromyalgia and interesting cystitis for me. Major flare on both right now. I'm sorry. I'm sorry if this is also giving you a flare. Hi, Rachel. Did I hear about how Anderson said they had a record for number of phones dropped in the water or acid and the data was lost at an unresponsive data farm in Kansas? To me, that's guilt. No, I don't think I saw that. I don't know. What? No, I guess that's what somebody's referring to, but I don't remember seeing that. Was that in the papers? All right. Well, they're saying the punitive damages are not warranted either, because there's no intent. But I think we just discussed that there's intent, so we agree that there's intent. So we're just going to skip through that. And they're saying that the jury's combined award for these claims that it occurred simultaneously, $25 million, again, well in excess of the maximum amount in Florida that can be awarded to the tobacco guys who chose to smoke. By the way, that's the difference. She didn't choose any of this. Her free will was not even at play here. Okay. Don't compare this to a smoker who chose to smoke for 50 years. And I'm not defending the tobacco companies, but I think it's apples and oranges here. I think it's apples and oranges. Hi, Nancy. You heard that on Megan Fox? Yeah, she didn't. I think she had Greg Anderson on there last night, right? But like not on video. It was only on audio, and I think he's been on there before. as a lawyer, I hesitate to interview any other lawyers about this case or any other cases that are still pending because, like I say, the case isn't over until the check clears. So I'm always afraid that I'm going to ask a question that someone's going to answer that's going to bite them in the ass, and then I'm going to feel bad about it. So I bet that was interesting. Yeah, I bet it was a cool thing. Then they're saying, yep, under the leadership of juror number 1 and all this good stuff. And, guys, this is already, we're 3.5 hours into this. I think we're going to continue this like tomorrow because if you want to, unless you just want to go onto the court website and read all of this good stuff yourself, because everything they say is about the battery. Now they're saying the battery that, we didn't really touch her, but if we touched her, it wasn't worth $8 million for the battery of taking the pictures, and therefore you should reduce it. And we should get a new trial. And if you're not going to give us a new trial, all right, reduce it to $50,000. And you're not entitled to, they're not entitled to punitive damages at all. But if they are, you should totally reduce them to an amount that we can swallow, which is some ridiculous number. And then they get to the Kathy Beatty stuff. Yeah. Please write that check. Mine needs to start living a life and healing. Mujer Barroca. Let's continue tomorrow. All right, we're gonna leave off here on page, because we digress a lot, you guys. We're on page 79. There's a couple of more claims to discuss, but I think they do deserve some more discussion than just trying to rush through it. And I know some of you want to get off and watch somebody else, which, I mean, I guess you're entitled. Well, right. Back to, we did nothing wrong. And if we did, it wasn't that bad, so don't sue us. Somebody said last night when I said this, that's the narc's prayer. Yep. I didn't do it. And if I did do it, it wasn't that bad. And even if it was that bad, I mean, you're totally overreacting because I didn't mean it. And even if I meant it, you shouldn't be so bothered by it. Right? Nope. They're not used to being held accountable at all. At all. Oh, thanks, Georgina. Thank you. Oh, Janine, I'm always talking about Gilgo Beach. Not only am I always talking about Gilgo Beach, but I go to court when Rex is in court. And last time that I was there in court, I did not go the day that his wife showed up, which I'm mad about, but I couldn't get there. He looked at me. He looked at me. He looked directly at me, and he stared me down. And it was chilling. Hi, Miku. Hi, Miko. Yeah, the narcissist spirit pickle nuts. Yes. So yes, I cover that extensively. I have an entire playlist. I can't even imagine how many videos are already on it for Lisk. But that is something else that I do cover. And also I cover, Jules sounds like my ex-husband. Oh, I think we've all known one or two of them in our lifetime. Dad, is that you? Yes, Anna, I want to do Delphi. I want to do deep dive into Delphi because I haven't done anything on Delphi yet. And I am so intrigued by so much of that case. It, like, just when you think it can't get any crazier, it is getting so crazy. It is getting so crazy. If I did it, you caused it. Yeah, that's the one I forgot. If I did it, it's your fault. It's all your fault. Yeah, that is eerie when he looked me right in the eye. It was creepy. Oh, well, he's always running late, isn't he? Isn't he always running late? Are you all gonna run? Are you all gonna run? It's sort of ironic. Rex looked at you and said, if I wasn't locked up, I would find you. Maybe, maybe he'll give me the jealous interview. Apparently, a lot of people are trying to come visit him. And he's not letting anybody come visit. But he's making pen pals. He has some pen pal. I think he's been pen pals with, like, this one of the other serial killers. Like the happy face killer, the smiley face killer, one of them. And yeah, Jules, the judge in that case is loony too. And let me tell you what, like, the more stuff that's coming out about those transcripts about her trying to get those lawyers off the case, like it makes you think, like, is she involved in this Odinism. And I got to tell you guys, from everything that I read, everyone's like, that's ridiculous. That's totally ridiculous. This was not a satanic ritual. This has nothing to do with Odinism. And then they make these allegations that these prison guards were wearing these patches. And everyone's like, that's ridiculous. They're not allowed to put any patches on their corrections uniforms. All they're allowed to have are the regular corrections patches. And I'm like, and then they get affidavits from the corrections officers who say, oh, yeah, we had patches. But they're not Odinism patches. It's a different pagan religion. And we took them off. So, I mean, I'm not a conspiracy theorist generally, but the more stuff that comes out about this case, the crazy Arnone lady, it's the Delphi case, Richard Allen, who's in prison in Indiana for the unalivings of those two adorable little girls, Libby and Abby. And all this stuff has come out. There were some crime scene photographs that were leaked by a mole who went into the defense counsel's office that used to work there, that used to be a friend. He took pictures of the crime scene photos and he sent them to some YouTubers. This is like so weird because all these YouTubers are all of a sudden being dragged into all this stuff. But he didn't send them directly to them. He sent them to another guy. And then the other guy sent them to the YouTubers and started distributing them. But then the guy that he sent them to unalived himself. And like everything that goes on in that case just keeps getting weirder and weirder and weirder. And yes, thank you, LA. So I'm on to conspiracy theories, and that case is causing me doubts. The only forensic evidence they have against Richard Allen, and you guys might be involved in this case more than I am, is an unspent bullet that was lodged in the ground near where they found the girls. But there's so much weirdness. Like one girl was wearing the other girl's clothing. They're saying that the bodies were posed and that there were these runes or these symbols that were made in the dirt that made it look like a satanic killing. They're saying that if he took these two girls there to the location where they were found, he would have had to forge through a river, and it couldn't have been like the whole thing is just so weird. Pickle Nets, go if this can. Do you know about this case? You know what also fascinates to me to no end is this whole like idea of like the satanistic ritualistic kind of thing. Like I used to read a lot of books like that when I was a kid, like the Edgar Allan Poe stuff, and like I love everything on Netflix that Mike Flanagan does, like all of those things with his wife Katie Siegel, these trying to think, like The Haunting of Hill House, and then he did another one that was about some crazy like religion and the cults. And you can get the court documents on this. You can look up the motion that the defense filed, and it is crazy. It's crazy. Yeah, it is crazy. And then when those corrections officers came out and said they really did have those patches on their uniforms, that's when I started thinking, that is nuts. That's nuts. Yes, Miko, those photos have been out since the case started. Yeah. And the guy from Texas who unalived asserted his right to a lawyer before talking to cops, and then magically, yes, that's what's so weird too. So that's the thing. Like, why is that judge forcing his public defenders off the case when those photos have been out there? I mean, it wasn't their fault. They were leaked. And then she threatens them in chambers that if they don't resign, she's going to read this whole statement about how improper they were and say all kinds of nasty things publicly about them. And then they said, well, we still want to represent him. We'll even do it pro bono. We'll do it for free. And she's like, no, you still can't represent him. I mean, the whole thing is really, really weird. Yeah, it's creepy. Yeah, Peter, it's a very weird case with sloppy law enforcement work. And Peter, being a retired law enforcement, can say that. It's ironic if that judge doesn't get off the case, it's going to be another retrial. Didn't she refuse his request? Yeah, for the attorneys to stay on. And they even said they would do it for free. Yeah, she has appointed other public defenders that maybe are her friends. Like, I don't even know what is going on out there in Indiana. And I'm not bashing anybody who lives in Indiana, but listen, we had a lot of corruption in Suffolk County for a long time too. And that's why it took at least 13 years for Rex Heuermann to be arrested when they had all of his information in the original case file going back to 2010, or at least a description of him. And being that he's 6'6" and an ogre, And he drove a first generation green Chevy Avalanche. It only took a couple of weeks for somebody who actually looked at the file in 2022 to put that together, and they knew who he was right away. So we know all about corruption in Suffolk County, but I don't know what's going on in Indiana, because this is call me Alice. It's another rabbit hole. And I just keep, every time I go to do it, more stuff keeps coming out. And I just feel like I just want to do one show, and just like anybody who's not into it, because it seems like a lot of you guys don't know a lot about it. It would be so cool to just do a whole show on just that and do like a catch up on it, because the trial's going to be coming up soon. Then we want to cover the trial, and it's a good like overview. So let me know if that's something you'd be interested in, because I'm here for you and I want to know what you guys. All right, Georgina, I'm happy to bring it to you. Yes. Yes, Deirdre. It's a small town cover up. Small towns have lots of secrets. I know. And sometimes I think, like, am I a conspiracy theorist? Do I watch too much TV? But I think this stuff really does happen. Why is everybody totally discounting the fact that this could have been some sort of a sacrificial ritual? Could have been, right? Why are we going to just ignore it? And the original police officers that started tracking this down were told to stop. There was a lot of ties to this Odinist community. So, it's really, really interesting. There's so many interesting, and I'm not saying, listen, innocent until proven guilty, right? I'm not saying whether Richard Allen did it or not. What I'm saying is there is so much other evidence. And just because he confessed to his wife over the phone from jail, he's being held in a prison, not a jail. He's supposed to be held in a jail until he's convicted, right? But he's being held in a prison because the warden says at the jail that we can't provide the protection for him. So he's being held in a prison with these two enormous corrections officers wearing these Odinist patches. And then he confesses to his wife on the phone like 3 times. Everyone knows all jailhouse calls are recorded. But he's saying it's because these 2 guys are like staring me down, and like they're maybe they threatened him and said, "We're going to kill your wife if you don't confess to this crime." Like, who knows? It is so crazy. Yes. All right, cool. I'm glad you guys are into that, because I'm looking for something else. We need another deep dive of something interesting. And to me, that is super, super interesting. Maya is going to stay with us for a long time, I have a feeling, but let's do it. Let's do it. All right, you guys, let's wrap this, because we have been on here for a very long time. And thank you to all my moderators who are so amazing and keep the chat classy, and to all of my warriors in the chat. I see you. I feel you. To all of my little cupcakes, my channel members, thank you for wanting to listen to me and for believing in me enough to want to be a member of my channel. To all my subscribers, thank you. It's free. Just hit the subscribe button below, and it really helps the YouTube algorithm. Also, if you could hit the like button on your way out, feel free to share the video, like it, comment on it. Something about the algorithm. I don't know. If I could figure out the algorithm, I'd be doing something else maybe. So thank you all. I appreciate you so much. I will see you real soon. If you'd like to come back here and do this again tomorrow and finish up this motion, which I kind of think Maya deserves that from us. Buy the Team Maya merch. All the proceeds, all my profits are going to CRPS research. I would love Jules. I don't know if you know how to get in touch with her, but if you want to give me your address, I'll send a t-shirt for Maya to you. If you can get it to her, that'll be super cool. My email is fanbase at mlittlelaw.com. You can always email me with show ideas or information. I know so many of you do. I don't always respond to the emails because I am swamped, but I always read them. So on that note, please hit the thumbs up. Thank you for liking me enough to want to hang around with me for so many hours on this crazy Tuesday. And I will see you guys again tomorrow. Peace. Oh, one more thing. Don't forget. Be cool, be kind, be classy. It's not hard. It's not hard.